pension scheme. My lord, I being the unmarried daughter, my lord, and I am entitled to the, my lord, as per the scheme, my lord.
Compassionate family pension.
My lord, compassionate family pension.
Then
Not, but it has not been paid. My lord.
what have you been granted? What have you been granted?
Nothing, my lord. Nothing.
You have been family pension has been approved or not?
No, no, my lord. Actually, the scheme says till the date of retirement of my father, my lord, the unmarried daughter or the other eligible persons, my lord, is entitled to the full salary.
No, that's as per the compassionate family
Compassionate
scheme.
family pension.
But what have you been given?
My lord, as per my instruction, we have not received any penny.
No, money not.
My lord.
Is there any approval or sanction given by the government? Money may not be.
No, my lord, the process has been done a little bit, but my lord, it has not been culminated into a logical conclusion that I can be given. My lord. That has not been done. My lord, in fact, no.
No. The Directorate of Pension has issued pension pay order in favor of the petitioner or not?
No, my lord, it has not been issued, my lord.
Huh?
No.
Then where is this order? The order of this court at para 4 says that.
Yes, my lord. The
That is
order.
the wrong order.
No, my lord. The para 4 says, my lord, may be pleased to find is at page 51 of my report.
No, para 4 of the order of this court
Yes,
of
my lord.
20/09/23. 20 September 23.
My lord. In this petition, my lord. My lord, it was no. Yes.
No, order of this court.
Order of this court, my lord. I have it is the submission made on behalf of the, my lord, by the learned counsel representing, but that has been recorded. But as per my instruction, my lord, nothing has been received till date, my lord.
I'm not talking about receipt, madam.
My
Mr.
lord.
Counsel. Why don't you understand the question?
My lord, yes, my lord, I have got the order, my lord. In paragraph 4, it has been said as the Directorate of Pension Assam
Yes.
issued by the pension pay
Has
order.
this order been issued? That is my question, not the money. Has the order been issued?
No, my lord.
Then this is a wrong. This is a wrong.
Wrong information given, my lord. That's for my instruction, my lord. That is required to be clarified, my lord.
Yes.
Lordship, as per instruction dated 10 February 2022, Your Lordship, the petitioner will be entitled to the unmarried daughter's family pension, that provision, Your Lordship. So since there's
Unmarried daughter's family pension.
Yes. After 2017, from 1st March it came, and probably it got issued in 2018. So whenever the petitioner will make the application for that, from there.
You mean for compassionate family pension?
Yes, Your Lordship. The unmarried daughter's family pension.
Compassionate.
Compassionate, yes, my lord.
He's saying family pension. He doesn't understand the difference between family pension and compassionate family pension. Which one is he entitled to?
Unmarried daughter's family pension, Your Lordship.
My respected friend has not gone through the scheme, my lord.
Have you gone through the scheme?
My lord.
Where is that? Which page?
It is in, my lord, page 35 of my writ petition, my lord.
Lordship, this is with regard to that means when the scheme of compassionate appointment went away, Your Lordship. So
What? Yeah.
compassionate
Correct.
appointment went away.
Correct.
So prior to that, after that, if the employee gets deceased, expires, then the concept of this.
Correct. No,
But this is he died on 27/2/2018. In his synopsis, it is stated
27
to 2018.
18, and the scheme came into effect on
1st April 2017. 1st March 2017.
where does it say that 1st March 2007? When has this scheme come into force?
My lord, in the year 2017, my lord.
Where?
1/4/2017. Notice in page 37, Your Lordship.
Page 37,
5.11.
yes. 1/4/2017.
My lord. So I am covered under the scheme, my lord. My father died.
Correct.
My lord.
Scheme came into effect in 2017. father dies in 2018.
It is sorry, definition of the 0.5 dependent upon the deduction.
When did you join?
My lord, Lord, it is not dispute that, my lord, I am not covered.
When did the father
Mild.
join his post?
That
Service.
instruction, my lord, I do not have.
Then how do we know? When?
Yes, my lord, it is very correct, my lord, that is required to be furnished, my lord. My lord, I can give the date of joining, my lord. He served more than, my lord, 20 years, my lord, that is sure. My lord,
Just a minute.
Mild.
In my pension is going to see my much cartoon. When were you born?
My lord, I born. My lord, at present, I am 22 years, my lord. I have given my credential in my additional affidavit. My lord.
What happened to your mother?
My lord, mother also died, my lord. I have only, my lord, now my three siblings who are, my lord, two elder brother and myself, my lord, and I am only eligible, my lord, as per the scheme, my lord.
But you'll be eligible only till you're 21 years of age.
No, my lord, if my lord, that amendment has been made, my lord, in this recent notification, my lord, may be pleased to find, is at page 43, my lord.
Okay, to an unmarried dependent daughter.
1980. My lord, my father joined in 1984, my lord. The instruction received, my lord.
And there was an earlier writ petition filed.
Yes, my lord. The earlier writ petition was filed and that order, my lord, may be pleased to find is at, my lord, page 50, my lord.
Look,
My lord.
when you filed the case in 2020,
My lord.
you were already a major.
Yes, above 18 years. Beyond 20 obviously an unmarried dependent beyond the hope. My lord, in the amended part at page 43, my lord.
Just a minute.
My lord.
Now, have you got this letter? 10 February 22.
No, my lord, I have not got it. It is an instruction perhaps received by my friend, my lord.
Will you may have to make a challenge, a prayer for setting aside this deduction? Have you got this?
My lord, I have received, my lord.
Have you put it to challenge?
No, my lord.
Have you challenged it?
Yes.
Is
My
it
lord,
necessary? Is it not necessary?
my lord, it is, my lord, my case is very simple, my lord. That I am an unmarried.
I know, it's
My
very
lord.
simple, but
They are,
since.
my lord, they are twisting and confusing the matter, my lord. I am as per the policy.
No, why haven't you put this thing to challenge?
My lord, pension matter, my lord.
What do you pension matter? There's a procedure to be followed.
My lord,
An order,
my lord,
whether it is, you see, an order issued
my lord.
is always deemed to be a valid order
Yes,
unless it is set aside by the
my
court.
lord, my lord.
Now, where is the prayer to set aside?
Because, my lord, it has come after this, my lord.
That is why I'm saying you
Yes, sir.
amend it.
Yes.
Or the best thing is you withdraw this with liberty to file a fresh and it becomes easier. Otherwise, it will take time. Because to amend it, you have to file an application for amendment. Amendment will be allowed.
It's a lengthy process.
Then what will happen is that it has to be again uploaded in the CIS. We cannot just accept it like earlier.
My lord.
If we could have accepted, put it on record, but then that does not work anymore. You'll have to put it to challenge.
My lord,
And then on the next day we can dispose it off because this is a simple thing.
simple matter, my lord.
Simple matter. Only thing is that
Yes, my lord.
this has to be put to challenge. You put this to challenge, and on the next day we'll dispose it off. It's very clear as the law is clear.
And
What
my
do you
lord, may
say?
adjourn for a week, my lord, and in the meantime, I will prepare a fresh one, my lord, the instruction. Adjourn for a week, my lord, this matter.
Or you file it now with this.
My lord,
Just
my
put
lord,
one,
my lord,
and then you file it by Friday. By Monday we dispose it
my
off.
lord, my lord.
Better. Or you want to waste time? It's clear. Everything is clear.
Then, my lord, may.
Yes. I'll do that. Mr. R. Bhuyan, let office for the petitioner submit that he may be allowed to withdraw the writ petition with liberty to file a fresh, in as much as the petitioner would like to make a challenge to the letter dated 10/2/2022 issued by the Director of Pension Assam. The prayer of the petitioner's counsel is allowed. I is accordingly the writ petition is accordingly dismissed as withdrawn, with liberty of speech. You file it by Friday.
My lord, represent their internal communication, my lord. They may object this letter, my lord.
How does it matter? It has been submitted before this court.
My lord. Then, my lord, maybe keep this as a.
What have I said? What have I said? Which has been produced in the court today by the counsel for the respondent. Mr. What is your name?
B. Deori,
Mr. B. Deori appears for the
government.
government. That takes care of that.
Obliged.
This matter is regarding a deduction of payment by
Huh?
deduction of payment.
Deduction of payment.
Yes, deduction of salary.
Reduction.
Yes.
Yes.
Deduction. My lord, petitioner's salary was deducted for the month of January without giving any information or notice, my lord. And when the petitioner approached the then vice principal of the schools, he refused to accept his application. And thereafter his
Yes, who is appearing?
my lord.
Who is appearing?
I'm making.
Yes, why is there reduction of her salary? His or her? His salary.
Numbers of representation he has submitted, my lord, not a single representation has been disposed of, my lord.
So you want the representation to be disposed of?
No, my lord.
Then,
I want to know the reason why my salary has.
huh?
I want to know the reason why.
No, we are asking.
Yes, ma'am.
Just wait. Let him give the answer.
But deduction was made by the principal of the school.
Is he a party?
Yes.
Has notice been served upon him? Ex-principal.
Yes, ex-principal, actually at that time, he was the DDO, my lord. He has deducted the salary. And then I have recently, my lord, I have included the present instance principal as a response number 6, my lord.
That's point number,
Response number 6. My lord.
but he's not here in the writ petition, he is not here.
I have already submitted the amended petition, my lord.
Amended writ petition.
Yes, my
Look.
lord.
Cost title,
Cost
yes,
title.
finally entered into the application that was allowed, my lord. Then
Amended cost title is not part of the record.
Submitted, my lord.
You have.
Yes, I have to verify.
No, has notice been issued to the respondent number 6?
No, my lord, no comment notice even issued.
Yes.
So, this
Huh? No, there is nothing here, right? The matter pertains to reduction of the petitioner's salary in the year 2023.
for the month of January. my
No, for the month of January 23. Also. The same apparently having been done by the retired principal of the school, that is respondent number 5.
He was not retired, my lord. He,
He is retired now. As on date, he is retired or not?
no,
Not retired.
he is still working.
Yeah, but he's not the principal.
Resigned from.
What do I say? By the ex-principal of the school, that is respondent number 5. The present principal of the school has been implemented as respondent number 6. Wide order dated 17/10/2023 passed in IA Civil number 3112 of 2020. Next paragraph. Though the counsel for the petitioner submits that the amended cost title has been filed before the registry of this format, the same is not a part of the report. Miss, what is your name? P. Goswami, learned counsel for the petitioner, shall inquire from the registry as to why the amended cost title has not been placed in the record. List the matter. Monday.
Better release to them front payment of arrears salary petitioner appointed as assistant teacher of
Mr. Counsel, this is for which period are you asking?
from 24/1/2006.
2006 to
1 year. To February 2027.
then isn't it hit by can we allow such late writ petition? You're coming after you have filed the writ petition when?
23 one.
23. That was 16 years ago.
In between, my lord, official communications were going on, my lord. On several occasions, my lord, the district, my lord, sent proposal to the director. But that was not released, my lord.
Huh?
On earlier 2 occasions, my lord, the district limited distribution sent proposal to the director to release the
Where is that proposal?
My lord, I have mentioned in FPR, my lord.
No, where is the proposal?
My lord, NSR 5, my lord. Yes, my lord, 22. This is the last proposal, my lord, sent by the district limited officer, my lord.
This is after 16 years, too late.
On earlier occasion also, my lord, proposals were sent to the director, my lord.
I've mentioned in paragraph 7, my lord. This is last proposal, my lord. I have annexed here. In paragraph 7, you Lakshmi kindly see, my lord. Page, I start from page 6, my lord.
No, you cannot file it after 17 years. 16, 17. You cannot file after suddenly one finding.
But official communications are going on, my lord.
Where official communication?
In 2013 also, my lord, proposals were sent, my lord.
2021.
In 20 was sent, my lord. Thereafter, my lord, in 21.
Yes,
I have received an instruction, my lord. Though the claim is a belated claim, but from the department, I have received an instruction, my lord.
yes. Okay, right. Heard, Mr.
Yes, my lord.
Jay Islam. Learned counsel for the petitioner who submits that the petitioner has not been paid arrears salary for the period from 24/1/2006 to 28/2/2007. Mr. N.J. Khatania, learned standing counsel, Elementary Education Department, submit that the Director, Elementary Education, Assam, has written a letter dated 10/10/2023 to the District Elementary Education Officer, Karimganj, asking him to furnish parawise comments along with fresh arrear salary proposal in the Finance Department prescribed format with the following documents duly countersigned by the competent authority, bracket S, full stop. 1, 2, 3, 4, 5, huh? That's it. The Mr. N.J. Khatania shall obtain instructions by the next day as to whether the District Elementary Education Officer Karimganj has sent the above documents in the Finance Department prescribed format to the Director of Elementary Education. Actually, you say issue notice. Huh? Before that, right? Issue notice, returnable in 3 weeks. Huh? Then at the bottom you write, and then you write, Mr. N.J. Khatania accept notice on behalf of
1, 2, 3, and 4, my lord.
1, 2, 3, and 4, while Mr. B who accept notice on behalf of point number 5. List the matter on give sometime in December. Notice.
Always.
Here our instructions are emitted. Created Lordship may issue notice, my lord. In the meantime, I will have the instruction. Regarding my lord, he's claiming, my lord, his transfer.
Transfer.
Yes.
So who has to take the decision?
Will be perhaps the respondent number 1.
So why the respondent one did not take the decision?
In this regard, my lord, let me have the instruction in that.
When?
My lord, by Monday, my lord, coming Monday.
Right. Two things they have taken for the instruction. Matter is very simple. The board is they have
No, anyway, what is your right?
Right. Yes.
What is your right to say that you have to be transferred? You don't have right. You cannot say that since I have asked for a transfer, I should be given transfer. You have got no right.
So,
So you wait. You have got no enforceable right.
the respondent number 1 has called for lower station from the board.
Maybe, but the final decision making authority is the respondent number 1.
Yes.
Just because proposals are made in your favor doesn't mean that that a right has accrued to you. There's no right. of transfer.
Well, that's what number, for transfer, my lord, it is, because the,
Mr. Council, let us not go into those issues.
it is service. it
You
is
have got no right as per, you show me the law, which says that you can be transferred to a place of your choice.
Transfer is a service event, my lord, it is
Huh?
that legal right, transfer is also service event.
No, no legal right,
It is
sorry,
legal right, my lord.
sorry.
So the legal right is
Show me
earlier than the.
show me a citation.
Then I'll, what is the judgment of under case, my lord?
Please do that.
Because this is legal right and legal right is violated, my lord.
He wants time till Monday. You don't want, you want me to dispose of this case, I'll dispose it of right now. You want me to dispose of this case, I'll dispose it of right now.
The service is legal right, my lord, so it is.
Heard
service
Mr. K.
event,
Sharma,
legal
learned
right.
counsel for the petitioner. Also heard Mr. B. Gogoi, learned counsel for the
Respondent one, my lord.
respondent number one.
Right.
Mr. D. Bora, learned government advocate appears for respondents number 2 and 3. Good, sir. The petitioner, by way of this writ petition, prays that he should be transferred to
From Borbeta to Vishwanath.
Vishwanath.
from Barpeta to Vishwanath
In the establishment of the office of the deputy commissioner.
in the office of the deputy, in the office of the establishment of the district commissioner.
Deputy commissioner. Deputy
District
commissioner.
commission.
Deputy commissioner, now district
Yes,
commissioner.
commissioner.
District commissioner Vishwanath.
Okay.
Good stuff. The anyway, actually, why should I ask you something? You take,
Yes,
you-
but
you-
Boy, two,
okay,
my lord, let me have the instruction.
you have the instruction by two, and we'll dispose it of that.
Only the authority will, my lord.
But
consider
please,
as-
Mr. Council, don't force your hand when you've got no right. At 2 o'clock,
Yes, my lord.
2 o'clock.
Huh? Okay. These are not taken the, today speak for receiving of the instruction, my lord. What has happened in this case, my lord, the petitioner was suspended, my lord.
Suspended when?
Yes, suspended, my lord, he is suspended on, my lord, 26/10/2022, my lord. It's more than a year.
Any DP initiated?
Yes, my lord, memorandum of charges has been submitted on 21st of January 2023, my lord. And since then, my lord,
Then?
we have been, my lord,
Then what remains?
but I am still in suspension, my lord. And now there was no review, my lord, of that order, my lord, so periodical review of the suspension order, my lord. So on that, my lord, the instruction was sought by the like court for on last of it.
No, but then DP has been initiated.
Yes.
Then what remains?
So if even then DP has been initiated, my lord, that review, the suspension review, or review has to be made, my lord.
In where is that citation?
My lord, I have, my lord, I have not, I want WBC number 2900 of 2023, my lord.
So,
My lord, I have not. 2900 of 2023. WBC. 2900 of 23. 23. My lord, there was an office memorandum, my lord, of the state, my lord, on which, my lord, the chief secretary has to take a decision for review of the suspension order within 6 months from the date of submission of the, my lord, memorandum of charge, my lord. So it is in January, my lord. So now we are in November.
show me the law.
Yes, my lord. I'm just, my lord.
What is the judgment that
Ajay Sharma.
Ajay Kumar Chaudhary?
Para 22, my lord. He says that once DP is initiated, my lord, because Ajay Chaudhary never got any relief from the
Correct.
order, my lord. So that will, my lord, come into force, my lord. Once DP initiated, no relief. Since Ajay.
Let us see the judgment that is referring to.
But even if the memorandum of charge being, there is a division bench judgment of the Honorable Court, my lord. One judgment. Which says, my lord, even if the memorandum of charges being, my lord, being served, my lord, the recent order must be passed for the extension of the suspension, my lord. Lordship may kindly see para number 3, my lord.
Para number 3.
Initially para number 3, my lord. The last two line, my lord, in this para, my lord. If the memorandum of charges is served, a reason order must be passed for extension of suspension.
And if it is not passed, then what happens?
So, my lord, periodical review has to be done, my lord, with the reason order, my lord. Suspension, he cannot.
It's only, you're relying only on 3. 3 has not specifically stated that.
This is very specific, my lord.
Let us,
In that case, my lord,
Yes.
the period of 6 months was not expired, my lord, in that case, my lord. So, my lord, time has been granted to take a decision, my lord. But in my case, the period of 6 months has expired, my lord.
this which para? In the division bench?
Yes, my lord, para 15 and 16, my lord. Okay,
15, 16 is different.
15, 16, my lord, it says about, my lord, that, my lord,
This is with regard to a case of whether Ajay Kumar Chaudhary would apply to a case of deemed suspension.
Yes.
Then,
deemed suspension.
what is deemed
There
suspension? What do you understand by the word deemed
Deemed
suspension?
suspension, if somebody is arrested, my lord, then he is.
Then?
My lord, may I kindly come to para 10 once, my lord. These are guidelines, my lord. Para 10, my lord. Roman 3, my lord.
Para 10 is different. It is when the charges cannot be, statement of allegations cannot be served within 3 months. Then what is to be done?
My lord, it says, my lord, when the person has been suspended, my lord, then there should be a periodical review after 90 days, my lord. So that
Periodical review
review
after
of the suspension order, my lord.
Huh?
Periodical review of the
Mr.
suspension.
Counsel, that is prior to the memorandum of charge being served.
My lord, if we go by this, my lord, even if the memorandum of charge being submitted, my lord, even then, my lord, a reason order.
No,
must have
where
been
does it
passed.
say that?
My lord, may I kindly see that the other judgment 2900, my lord, in that judgment is there, my lord, which is a submission of, my lord, the other side in that case, my lord. There is a office memorandum of 4/2/2020, my lord. That para number, my lord, it is 5, it is there, my lord. That the decision has to be taken by the chief secretary within 6 months from the date of submission, my lord. In para number 5, it is there, my lord.
Yes, there is this.
Yes.
There is this office OM
Yeah.
dated 4/2/2020.
Lordship, what my friend is submitting, Lordship, is contrary to his feeling, Lordship. Lordship, may kindly see prayer C,
Page,
page 27. Prayer C.
yes,
Lordship, what he is praying, Lordship, directing the respondent authorities to review and reconsider the suspension of the petitioner. And my instruction says, Lordship, DP has already been initiated and it's about 1 week time, Lordship, within which it will be concluded, Lordship. Most importantly, Lordship will see Ajay Kumar Chaudhury's husband, paragraph 22, Lordship. Same thing, Lordship. Memorandum of surset was issued. So in that case also, Lordship, first.
no, but out here, there is a OM issued by your chief secretary.
OM is there, Lordship.
So the OM says that a review has to be made within a period of 6 months from the date of submission of the memorandum of charge.
Yes.
So now this OM has to be applicable.
In case of GMC, Lordship, whether it has been adopted or not, that is the.
In case of GMC only, my lord.
Huh?
This is in case of GMC, my lord.
GMC.
Yes, yes. DMC hoita.
So apparently, Lordship, so far as my instruction on is concerned, Lordship, review could not have been done, Lordship, as the file was with the inquiry.
For my lord.
So let us.
No, but then your prayer out here is for review.
Yes.
My lord, I have made
And
prayer.
huh?
My lord,
His
na
statement
prayer-
prayer is
my lord, na
not
prayer C, my lord, prayer A and B, my lord.
In the first prayer, Lordship, he is praying for
I'm
setting
praying
aside
for
of the
suspension,
suspension
for-
itself. Lordship.
For setting aside, my lord.
For that, the second, Lordship, for
I will not,
further
I will not
notification.
stress on C, my lord.
We also not to
I will
give
not
a
press
further
C, my
effect to the suspension order.
Where is the OM?
That why, my lord, I don't have, my lord, because I have, because it-
You don't have anything. You bring the OM.
my lord, my lord, I'll do it.
You don't have anything. Yeah.
OM, my lord, I will try to find out, my lord, because
The-
they are OM, my lord, he is with them, maybe with them. Even then I will try to find out. My lord. Yes.
This could have been got by you. You got it
Yes.
from here. What is this? Mr.
G alone.
G. Alam. Senate counsel for the petitioner submits them. The petitioner was suspended on 26/10/2020. And memorandum of charge was issued on
25/1/23.
25/1/23. However, as no review has been undertaken by the government for extension of the suspension period in terms of the OM dated 4/2/2020 issued by the chief secretary to the government of Assam, where it has been stated that review has to be made within a period of 6 months from the date of submission of the memorandum of charge, the suspension of the petitioner's service, the suspension of the petitioner should be set aside. In this regard, he has relied upon the order dated 24/5/23 passed by this court in WPC 2900/2020. Issue notice. Mr. P. Naik accepts notice on behalf of respondent numbers.
Lordship. Lordship, I am appearing for 1, 2, 3, and 4, Lordship.
1 to 4. Who is for GMC?
GMC, Lordship, I am appearing.
Oh, yeah, so 1 to 5, that means
1 to 5, Lordship. Sorry.
1 to 5. And municipal administration, Mr. R. Dhar appears for respondent number 6. List the matter on. No, as the petitioner has not produced the OM dated 4/2/2022, 2020, list the matter on give a date. After next month, first week or something. This is the matter on
6 December. December. Obliged.
Lordship, matter relating to family pension and DCRG to the widow of a deceased employee, Lordship. Pension papers have already been forwarded to the AG for sanction, Lordship, and on the last occasion, my senior friend has sought time to seek instruction.
Well, it is not sent, my lord. I have to receive a letter from my lord. You know,
To what effect?
well, so far this pension paper and other documents not sent from the government to.
Not sent.
Yes, but it is my, this is my letter.
Lordship, here one copy is enclosed in page number 41 of the 81.
But it is not here.
Copy is enclosed, so that may, whatever that thing is, perhaps that is what they are indicating, your Lordship, and that maybe that if I can have access to that copy. Page number 41, your Lordship will see with reference to the subject cited above, and that to the inform you the Transformation and Development Department has already forwarded the pension papers to Office of the Accountant General for sanction of final pension and DCRG within bracket copy enclosed. That copy has not been enclosed in this writ petition, your Lordship. That perhaps may give an indication. We'll have to.
And there is private respondent also, my lord.
Huh?
There is private respondent also, my lord. Another white, my lord.
Private?
This is another wife is there, my lord.
Another?
Double wife. It's a double
Double
wife,
wife.
Lordship. So
Two wives.
Yes.
two wives. There is a private respondent.
Don't say
also.
double wife. What do you mean double wife?
Two wives.
Two wife.
Two wives.
There be a double wife. Double decker or what? Double decker bus. What is it?
Otherwise, Lordship, from the records which we have enclosed with the writ
Just a
petition.
minute. Yes, so this letter is there,
Yes, my lord.
but then where is your forwarding letter to the office of the accountant general?
That is what this copy enclosed, that this has come from motion. I don't have any other.
Where is this copy enclosed?
Lordship, actually, this letter was given to the council. He had issued a lawyer's notice against that he has received this letter, but we could not collect it from the advocate, Lordship.
Then
He has
what to
given us
do?
only.
Then what you expect me to run around to do your job for you?
No, Lordship, they can seek instruction, Lordship. Actually,
Mr. Counsel, when a letter has been issued to you, to whoever this SS data, you collect from SS data all the documents. Why should they give you 2-3 copies? 1 copy is enough. Who are you?
no, otherwise, Lordship, I being the wife, Lordship, that is reflected in the nomination.
Mr. Counsel, the issue is what documents you have submitted, we do not know. Now, this is a question of fact. The question of fact, you prove your case first, when these are the documents that you have submitted. And we can ask them, is these documents enough? Once they say, yes, it is enough. And end of the matter, we tell them to process. What is the documents? You see, first of all, you have said that you have already forwarded it to the accountant general's office. Where is your forwarding letter?
That is what that must be the copy enclosed that thing, your Lordship. Otherwise, we are relying on this document only at this stage, your Lordship.
This is only copy enclosed. So you will be having a copy
Yes.
in your own. Then you bring the report.
What
You
I'm saying-
also get.
That's what I'm saying, your Lordship.
Both of you.
Had he enclosed it, then matter would have become simpler, your Lordship. That's what.
Okay, right. This is writ petition. The petition I have paid for grant of family pension and DCRG on the death of her husband while in service, due to the death of her husband in hardness. Full stop.
No, after retirement.
After retirement, or due to the death of her husband after retirement. Full stop. Mr. S.K. Mehdi, counsel for the AG's office.
Accountant, yes.
AG's office submits them. The pension proposal papers have not been received by the office of the AG. SM. A perusal of Annexure 11 of the writ petition shows that The Deputy Secretary to the Government of Assam Transformation and Development Department has written a letter to Mr. S. Datta, Advocate, stating that the Transformation and Development Department has forwarded the pension papers of the petitioner for sanction of final pension and DCRG to the Office of the Accountant General. It also says that copy is enclosed. However, the petitioner has not annexed the copy enclosed as referred to in the letter dated 2/3/2023 issued by the Deputy Secretary to the Government of Assam Transformation and Development Department. Mr. No, the petitioner's counsel shall submit shall produce the copy enclosed as referred to in the above letter on the next day. Mr.
CS Hazarika.
C.S. Hazarika, learned counsel for the Transformation and Development Department, shall also produce the records showing the forwarding letter sent by the department to the office of the AG, Assam, for sanctioning the final pension and DCRG payable to the petitioner. List the matter on when, both of you.
Next week will be required, 3 weeks will be required for records, 2 weeks.
Give a date.
Can it be 12 December?
Huh?
12 December,
12 December. 12.
much obliged.
You get that, that's the end of the matter. Why are you delaying the matter?
Actually, we don't have it.
You don't have it.
Yes. Otherwise, we would have enclosed it also.
Then where is your statement that it's not there? It was not there. You ask from the council, might be there. I don't think they'll write copy and close without it being there.
Well, my letter will be in record.
Huh?
My letter will be in record.
The letter.
Government will certainly have it.
The letter dated 18/10/2023 issued by the senior accounts officer is made a part of the record and marked as Annex X.
Hello. Much obliged.
Yes.
Excellent. As per line.
Rupen, Gura, Gohain, and 5 others. How many are you?
6.
6%. So. What does it? What?
While forwarding the proposal, there was a mistake, my lord. So we were asked to correct the mistake and resubmit it, my lord. My lord, may at least issue notice, my lord. I'll obtain the.
Okay, right. Heard Mr. B. Professor Learned Counsel for the petitioner to submit that the petitioners have not been paid their salary from 10/20/10/2012 to 28/2/2015. Next paragraph. Mr. N.J. Khatania, the learned counsel for the Elementary Education Department, submits that the Director Elementary Education has written a letter dated 14/11/2023 to the effect that an area salary proposal for rupees 27,76,080 had been made for disbursement to the petitioners. However, due to a mistake made in the proposal for sanction of the said amount, comma, corrected proposal is going to be sent or has been sent?
It's going to be sent, man.
Is going to be sent within,
3 weeks, my lord.
no, it's going to be sent. Full stop. List the matter on, give first week. No, they're going to be sent. Full stop. Issue notice. Returnable in 2 weeks. Which then they accept notice on behalf of all the respondents.
Not my lord, 1 to 5, my lord.
1 to 5, while Mr. P. Naik accepts notice on behalf of 6 and 7. Full stop. 6 and 7, there is 6 and 7. Full stop. The Director, Elementary Education Department should send the corrected proposal for sanction of the arrear salary amount within a period of 1 week from today. List the matter on.
Proposal will be sent by the
Later.
district elementary education officer, madam. It is sent by the district elementary education officer
Should be sent by the District Elementary Education of Lakhimpur
to the.
to the director
Yes, ma'am.
within 1 week from today. List the matter on. The letter dated 14/11/2023 issued by the director is made a part of the record and marked as an Annexure X.
Obliged, Lordship.
Non-payment of salary and allowances upon retrospective promotion due to non-relaxation of FR 17. FR 17 has to be relaxed upon retrospective promotion. Mr. Gogoi was asked to, standing council, Mr. Gogoi was asked to obtain instruction on last day. Whether any instruction is received or not, my
Where is Mr. Gogoi?
B Gogoi, my.
I know. No, but then what is there to be, what is there?
My lord may be directed to relax the FR 17 because I have to retire on my retirement date is on August 24, my. Normally,
You see, the promotion was made when?
a promotion was made on 19th, on 20, my lord.
20 when? Date.
Date, I am giving the date, my.
Where is the promotion order?
My lord, I am giving. This is the promotion on page 17, my lord. Page 17. With retrospective effect from 7/11/2020, Mr. Robindra Deka, Inspector Food and Civil Services, as a Superintendent Food and Civil Supply. Till then, his pay and allowances has not been received. Due to
So with effect from 17. With effect from
7/11/2020.
Then what happened?
My lord, Lordship may kindly see page 19, my lord.
Yes.
Page 19, this is the letter from the AG, my lord, to the Secretary Food and Civil Supply. Requesting to relax the FR 17, my lord, because it is a retrospective promotion. That is not done.
Just a minute.
Lordship may kindly peruse also page 18, my lord. This is the letter from the.
Just a minute, just a minute, just a minute. Maybe FR 17 out here.
FR 17.
Why is relaxation required?
But because FR 17 says pay and allowance is applicable from the date of assumed charges.
Ah,
In case of retrospective
where
promotion,
he
he has
did
to
not,
be relaxed.
he did not assume charge that time.
My lord, he is not in the office there.
He is not in the office at all.
My lord. That is the rule. There is judgment also from the honorable court also, my lord. Even Supreme Court, there is a in Janaki Raman's case, my lord. Supreme Court also emphasized this.
Yes, who is for the, who is, Mr. Gogoi is not here, what to do? You're there, Mr. Bora.
No, I am for the director students department.
Who has to relax? FR 17.
My lord, they has to, the primary duty is to relax the
By whom? Which
by the
department?
secretary food and civil supply. But the file is moving to the through finance file. It was pending in the finance. Lordship, kindly
No, but the relaxation has to be first given by, proposal has to be given by the food and civil supply.
my lord, already there is a clarification from the food and civil supplies, my lord. Lordship, kindly see page 18, my lord.
18 years.
Yeah, this is the type copy of the letter, my lord. Departmental Selection Committee in its meeting held on such and such has recommended Shri Ravindra Dekar, Division Inspector Tutor for his promotion to the next cadre of the superintendent, but decided to keep the recommendation in a seal cover due to pending departmental proceeding against him. After conclusion of the same departmental proceeding drawn up against Ravindra Dekar, the inspector Kubulans a complete exoneration from the charges level against him. He was promoted the post of superintendent, my lord. Next, further APSC also conveyed his approval for the selection. Next, accordingly, on the basis of the approval, APSC department has regularized the officiating promotion of 20 number, including this petitioner.
Now what to do?
Now, Lordship may see the AG's letter. AG is requesting to relax the FR 17, but nothing is forthcoming from the department.
Lordship, let me see, let notice be issued. Let me see.
My lord, I am retiring, my lord. On that count,
You are retiring when?
August, my lord.
This letter is dated 13 October 2022.
So, you had enough time.
Page 19. So,
You had enough time.
you had enough time to approach your lordship.
You had enough time to consider this. One year gone.
That's what some time may be granted to.
For why some more time? 1 year gone already.
Your lordship, this matter has come from motion for the first time.
No, this is the second time, my lord. First time. If his
Yes.
notice is given, my lord, it will be kept in the registry, my lord.
Some time may be granted 1 week. time.
Considering my submission, my lord, Mr. Gogoi was asked to obtain the instruction why the file is pending, why it is not relaxing the.
No, but before the finance department can relax, finance department will only give approval, I think.
Again, yes.
The proposal will have to come from the
They have
concerned
to,
department.
they have to give the letter to the AC, my lord.
So let me seek instruction.
Okay,
whether
right.
after this
Third,
30
Mr. D.
I
N.
am D. N.
Bhattacharya,
Bhattacharya.
learned counsel for the petition, who submits that the petitioner was promoted temporarily and allowed to officiate as superintendent of food, civil supplies and consumer affairs under regulation 4(d) of the Assam Public Service Commission (limitation of functions) close regulation, 1951, hereinafter referred to as the 1951 regulation. Wide notification dated 19/8/2021, issued by the Secretary to the Government of Assam, FCS and CA Department. Acha, with effect from actually, with effect from 7/11/2020. Wide notification date itself. Okay. The Secretary to the Government of Assam, FCS and CA Department thereafter wrote a letter dated 27/7/22 to the Senior Accounts Officer, Office of the Principal Accountant General, bracket ANF, bracket close Assam, stating that the DPC in its meeting held on 8/10/2020 had recommended the petitioner for promotion to the next cadre of Superintendent, FCS and CA, but decided to keep the recommendation in a sealed cover due to a pending departmental proceeding against him. After conclusion of the departmental proceeding, wherein he was completely exonerated from the charges leveled against him, he was promoted to the post of Superintendent, FCS and CA with retrospective effect from 7/11/2020. Wide notification dated 19/8/2021. Thereafter, now further, the Assam Public Service Commission have conveyed their approvals for selection for promotion of the petitioner to the post of Superintendent, FCS and CA. By letter dated 10/1/2022. Accordingly, on the basis of the approval given by the APSC for regularizing the officiating promotion of the petitioner made under Regulation 4D of the 1951 regulation, with effect from the date of taking over the child, via notification dated 25/2/2022. No, what have I said? Accordingly. No, don't say that. Accordingly, the APC had no. Accordingly, on the basis of the approval of the APSC, the department had regularized the beginning. Okay. Okay, you got it? It should be on the top. Had regularized. The department had regularized the officiating promotion. Okay. Next para. Next para, the Senior Accounts Officer, Office of the Accountant General, bracket ANESM, thereafter wrote a letter dated 13/10/22. Is it 13/10? No.
It looks like 17.
13.
Is it 13?
13/10/22 to the Secretary, Food, FCS and CA Department, stating that the petitioner's promotion to the post of Superintendent FCA and CA under 4D of the 1951 regulation had been regularized by letter dated 25/2/2022. However, it was not clear whether FR 17 had been relaxed for authorizing pay and allowances from the date of retrospective date of promotion. And as such, the secretary to the government of Assam FC and CA department was requested to review and clarify the factual position with regard to whether FR 17 had been relaxed in relation to the petition. Yes, what is to be done?
We have already written to the Secretary of the Government of Assam to the civil supply. And the government is therefore requested to review and verify the file.
Who is this? Who are you?
I'm accountant general.
That the way, no. Okay, that's the way I've mentioned. Now, only thing is that they have to do it.
We have communicated.
So what we can do is we can ask the secretary to take a decision.
Lordship may direct to relax FR 17, my lord.
Right.
Let them take a decision either
Within-
this way or that way.
My lord, within a fixed period.
Yes. Pusta. The next para, the petitions council submits that as the secretary to the government of Assam FCS and CA department has not made any clarification with regard to whether FR 17 was relaxed for authorizing pay and allowances to the petitioner from the date of his retrospective promotion, that is 7/11/2020, the petitioner submitted a representation dated 8/9/2023 to the respondent number,
The respondent number one.
to the respondent number one. However, the respondent number one has not taken a decision to the same, in respect of the same children. He accordingly submits that the secretary to the government of Assam, FCS and CA should take a decision on the same within a specified time period. And necessary approval the necessary approval should be obtained from the finance department. If the decision is to relax FR 17. Next para, Mr. D. Bora appearing for the FCS and CA department, Mr. R. Dhar appearing for the Accountant General's office, and Mr. P. Nayak appearing for the Finance Department, submit that they do not have any objection to the prayer made by the petitioner's counsel. In view of the consent of the parties, the secretary to the government of Assam, FCS and CA department is directed to take a decision. Is directed to consider the petitioner's representation dated 8/9/2023 and take a decision on the same within a period of 2 weeks. 2 weeks from the date of receipt of a certified copy of this order. In the event the Secretary of the Government of Assam, FCS and CA Department takes a decision to relax FR 17 for authorizing paying allowances to the petitioner from the date of retrospective promotion, necessary approval for the same should be sought for from the Finance Department within a further period of 2 weeks thereafter. And the amount should thereafter be paid to the petitioner. Naturally, depending upon, I said, depending upon the decision taken. The writ petition is accordingly disposed of. So that way, at least, now if they don't do it within a time period, at least you can file contempt. Actually, you have to give, I think, according to me, you have to give, you have got to give relaxation. Because the retrospective promotion have been regularized. But I will leaving it to you to take a decision. Because I don't think you've got any avenue to take a different view. Let them take a decision.
My lord, my problem is that my date of retirement is August, my lord. Only 8 or 9 months is left, my lord. If this process is going on, my retirement benefit will be held up. I am not.
That is why we have disposed it off.
I am not.
Mr. Counsel.
I am not receiving the pay allowance from 2020.
Mr. Counsel. This is this is regarding payment of money.
Right.
It is not an irreparable injury. It is a repairable injury. So don't worry. And let them take the decision within 2 weeks. Then you'll know. Within 2 weeks, if the decision is not in your favor, then you come to the court.
It is a multiplication of proceeding, nothing else.
It is
Multiply, go on multiplying, and the petitioner will go and suffer.
Okay, we'll give them time. We'll sketch out the order. Mr. B. Goy will give him a month to take he'll come after 1 month. He'll again ask for time.
Let the matter be pending. Let them come without what the decision is done. While our chief is disposing the petition.
Okay, we'll issue. We'll issue.
Let the matter be pending. Let them obtain the.
No, heard. Then so you heard. You say. Okay, heard, and then you say. Because I thought, you see, if they don't follow, then at least you can file contempt.
My lord,
and everything.
If from 2020, from the 19, they are not doing anything, my lord.
Mr. Counsel, they were not doing anything from 2020.
Even after approaching the court.
And when did you come to the court? You came to the court in October 18th.
My lord.
That is not even a month back.
No, my lord.
Issue notice returnable in 4 weeks. Mr. Arthur accepts notice on behalf of the Accountant General's Office. Mr. P. Naik accepts notice on behalf of the Finance Department. Mr. D. Bora accepts notice on behalf of the 183 is the matter after 4 weeks to enable the Respondents' Council to obtain instructions. Extra copies of the writ petition to be provided to the council for the response.
May I please?
Yes.
The petitioners, 5 petitioners before your lordship, their LP school teacher, they have joined their duties in the year 2001, in the March 2001, and therefore they are entitled to old pension scheme and GPF account. But they have not entitled, and this case is covered by the judgment by the Honorable Court.
You have not been given pension and GPF.
GPF is the old pension scheme. And this case already decided by the school in common judgment. I have given. The appointment was again regular vacant post. And the common judgment decided flag mark your lordship. Estimated teacher start from page 329. Yes, your flag mark your right.
Start from flag mark, page 320, start 70 teacher. Petitioners
You
and
you
page,
just type out the entire thing, huh? Then we'll issue notice. Type out the entire thing, then we'll issue it. Yes,
yeah,
yes, what to do, Mr. Kataria?
page 3,
My lord, may it is short notice, I will examine whether it is covered by or not with the department. And my lord, may dispose it on the next day.
So you have to take-
already I-
Mr. NJ Mr. Heard, Mr.
yes, Islam.
Islam Learned Counsel for the petitioner who submits that the petitioners were appointed as regular assistant teachers in different LP schools under the DEO Lakhimpur. Right, orders issued in the year 2001, and they joined their duty and they joined their post in the year 2001. However, GPF account numbers have not been allotted to the petitioners till date. The petitioners being stipendary teachers, the case of the petitioners are covered by the judgment passed in WPC number 6403/2021. The petitioners counsel thus submits that as the present case is a covered case. A similar order should be passed in this case. Mr. NJ Khatanir appearing for
And for the respondent number 1, 4, 5, 6, and 7, my lord.
1, 4, 5, 6, 7. And Mr. and Miss Jdas for respondent number 3 and Mr. P Nayak for respondent number 2. Submit that they will examine the order passed in WPC 6403/2021 to ascertain whether the present case is a covered case. List the matter on when?
Next week, man.
List the matter next week.
Okay.
No.
Made, your lordship, my lord, petitioner is, my lord, working as field officer, my lord, in disaster management, my lord, department, seeking implementation of 7th pay commission, your lordship. Similar matters are,
Mr. Counsel, are you a regular employee?
no, my lord. But there is a recommendation, my lord, so far as I am concerned, your lordship.
Recommendation is a recommendation, Mr. Counsel.
My,
The fact remains that you're not a government employee, you're a regular government
On
employee. You're a contractual. So your conditions of service is governed by your contract.
but others they have given, your lord.
Maybe, doesn't matter.
In the same department, my lord, they have implemented that accordingly, this honorable.
Who? Show me who have they implemented?
My lord, that your lordship will see at page, first your lordship, page 44, your lordship. After so many meetings, your lordship, this is the recommendation, and thereafter, my lord, page 46.
Yes,
46, my lord. They have given, my lord, in the disaster, these are the candidates, your lordship. My lord, at this stage, my lord, I am praying for notice and similar matters are pending.
no, wait.
My,
I don't know why I should allow.
my,
Yes,
in fact, your lordship.
yes, so where is the petitioner?
My lord,
Who is the petitioner here? Manash Pratim.
my lord. In fact, my lord, a number of meetings were held, your lordship. In that meeting, it was, my lord.
What is the post held by you?
My lord, field officer, my lord.
Any field officer are here?
Here, not field officer, but other non-sanctioned post, my lord, in the same department, on the same footing, your lordship, they have given. So far as field officers are concerned, my lord, it has been recommended on honorable CM, my lord, has taken decision, my lord, it has to be given, but my lord, my lord, a number of meetings were held, but it has not been given, your lordship. And decision are also, my lord, taken for sanctioning the post also, your lordship.
What are the rates? What are the pay scales approved?
My
pay
lord,
scales?
we right now we are, my lord, 30, it will come on number 30,000 to 1,10,000.
From where? From where do you get this?
My lord,
From where do you get this
seventh pay
magic
commission,
figure?
your lordship, that I am,
No, what is the equivalent? What is the equivalent cadre or grade for this engineering consultant earthquake mitigation?
my lord, that your lordship will see my appointment letter, that page 24, your lordship. With reference to the, I am enclosed here with the terms and conditions of the contractual, field officer, disaster management, so and so. You are requested to, and these are the terms and conditions, your lordship.
Where are the terms and conditions?
They have no annex, my lord,
No, it
any,
is
my lord,
not
that
there.
contractual.
It is not there in this.
Then
This is an, if you read my lord, subject, letter of engagement, this is not an appointment, it's just an engagement.
he's on contract basis.
Contact with me. I am not
Contact.
disputing. I
Then
am,
where is your case?
I am that, when it was recommended, your lordship,
What is recommended?
my lord, to give me, my lord, 7th pay commission, your lordship. Pay scale of 7,
Where? Pay what pay scale?
page 44, your lordship, can you see?
Page 44.
Page 44. May I read, your lordship?
There.
This is regarding implementation of the proposal for strengthening the service conditions of so and so employees by enacting the service rule to be placed before the cabinet for regularization of service of so and so employee. Where it is in the subsequent.
Has it been placed before the cabinet?
My lord, in the meeting, your lordship, that your lordship will see. Page 25. Annex 3,
Mr. Counsel,
my lord.
I know you want to better your service condition, no problem. That is expected.
My,
You should. And there are some meetings which appear to make a move for bettering your service condition.
my lord,
But that by itself does not give you any right.
my lord. But when they have given to others, your lordship.
No,
On
how,
the-
how are they given to others?
My
Show
lord,
me.
here lordship, see, in this regard, you are hereby requested to. It was written to my lord, honorable minister to chief secretary, your lordship.
Where?
Requested to-
Where?
On my lord,
Page,
8 June 2000, page 44, my lord.
page 44. Where?
In this regard, you are hereby requested to make necessary arrangement for sanctioning the non-sanctioned post of so and so within bracket, my lord, project officer, DM, field officer, disaster management, inform so and so, with an ideal salary structure and placed before the undersigned at the earliest, amending all formalities so that the same could be incorporated along with the service regulation file, which is in the process before the cabinet itself. This may be treated as priority. My lord, in my humble submission, my lord, I'm entitled, since.
You have no right. No
You have
right.
6
You've got no right. This is only a proposal. Proposal said.
Since my lord, the right accrues, my lord, the moment they have given to
No,
others,
no,
my lord,
no,
I,
no.
in my
Show me
humble-
the law is not like that. Mr.
let them, my
Counsel.
lord, I will
Is this
satisfy.
no, you should satisfy me now. Where is the enforceable right? Where is the enforceable right that you have?
My lord,
You
when,
have to satisfy
when
me.
my lord cabinet and my lord honorable minister is saying, your lord,
Where is the cabinet? You see one thing,
my lord,
the law is that
My-
a cabinet decision is not enforceable in law. It's only when there is an action taken
My-
by the government on the basis of the cabinet decision that it becomes enforceable in law.
to your lord.
And now in this case,
page-
the cabinet has not taken any decision.
My lord, page 46,
46, yes.
it is in respect of other employee working in disaster
As
management. on
per
contractual-
approval, just a minute.
My lord,
As per approval of the State Executive Committee of Assam State Disaster Management Authority.
My-
Of an authority, not the government.
My-
And as per the concurrence of the Finance Department,
My-
allows the following employees to get the benefit of the corresponding pay scale so. But out here, your department, your post is not included. Field officer is not included here.
Here, my lord,
Where?
page 44.
Mr. Council,
But here
44 is a different thing.
Here
46
it is not there. What I am submitting before your lordship, my lord. Here it is not there,
And then you please come to 47.
my lord. These are
What
the-
does it say?
My lord, district project officer, my lord. Page 47.
47 also is not there. Field officer is again not there.
Here not, that's why I am saying, my lord, they have given to others, but so far as field officer is concerned, my lord, it is not given. That's why I am before your lordship.
Yes. What is the submission?
Your lordship may examine. my lord.
My understanding is this quarter and this 44. In terms of the
In terms of? Aha.
for last time of the first semester.
Where? For first page 44.
46, page 46.
46. Yes.
But still their tenure of
Contract is in force. Ah. It is basically Jagdish Singh's case. That you get the minimum pay scale. That's all. Minimum pay scale. Minimum pay scale you get.
As per, my lord, this, my lord, I am entitled for, my lord, 30,000 to 1,10,000 pay scale. Now I am getting only 16,000 dollars. Oh, my lord,
No. You're getting only 16,000.
16,000, 16, 17.
Okay, let us see your pleading.
20,000.
Your pleading says 2,40,000. 2,40,000 you divide by 12.
My lord.
Yeah, 12 months.
12,000.
20,000. So where is 16,000?
No, my lord, 20.
Your
My-
mouth
my
says something,
my
your brain says something.
My apology. My lord, since other matters are, my lord, your lordship.
No.
examine.
You tell me now. Where is your representation to the authority?
My lord.
45.
Yes. My lord, page 41, annex 10, page 41.
Yeah.
Prayer for awarding an ideal scale as per the revision pay of,
You write to the minister.
my lord. Before that also, my lord,
What is your prayer here?
prayer is your lordship. Page 17. Sanctioning the post, my lord, because recommendation was also given for
You
sanction.
got no right
My
for a
lord,
pay for a
Second,
pay.
your lordship return directing to award an ideal salary for the post of petitioner similar to the 57 numbers of sanction post under
Where page?
page 17, my lord, 17. Prayer number 2. In my petition, your lordship.
Page 17 is your prayer. I am asking for your representation.
Representation that I have played, page 41, my lord. In this regard, we pray your honor at the bottom, my lord, to consider the post of field officer as similar to the post of junior information public relation officer under the information and public relation department, Assam. Age qualification required for the post is almost the same with that of the post of field officer, scale of so and so. Advertisement published for the post of field officer, wide vacancy announcement so and so are enclosed here. Hope your honor please apply.
Mr. Counsel, can this court direct the minister?
No, Lord.
Thereafter, my lord, meetings were held, page 42.
Mr. Counsel, can this court direct the minister to then? If it cannot direct the minister, then why don't you file a?
Other representations are also that it may not be, I will file additional.
No, not allowed.
And page 42, these are the meetings, my lord, held.
Okay,
Page
good. Nice try, Mr. Counsel, your time. And what is this, page 45? Where is the translated version?
Nothing, Lord. And it is also incomplete.
It is also incomplete.
CC for information regarding.
Who is it addressed to? I do not know.
To the honorable minister, Lord.
Again to the minister. He only goes that level.
My lord, we approach other authorities also. It is not there.
You see, what you do is, best is, you file a fresh representation to the authorities.
Fine.
to the secretary of the concerned thing with regard to your prayer
My lord.
for giving you the pay scale of whatever, I do not know, but
7th pay scale.
whatever.
My lord.
But then you're a contract employee anyway.
My lord, so far as my employment, I am not on that. So far as my payment part, salary part, I am before your lordship because of that.
Because you see, the Jagjit Singh's case,
My lord.
Supreme Court, we write that down.
My-
And also Upendas have clearly held that you can only get the minimum scale of pay. That's all. You cannot get beyond that. There is no case.
But in that case, what your
So
lordship
that
has
is why you can write a letter to them.
to the lordship.
There's no problem in making a prayer to them. But legally, I don't find any case. But then this court cannot allow this petition for the simple reason. First of all, you're a contract employee. You are bound by the terms and conditions of your contract. There is no prayer in your writ petition that the terms and conditions of a contract should be set aside and you should be given the 7th pay commission.
I'm only on because the others they have given. That's why I'm equally so far as Article 14 is concerned. Because of that, and
They have not been given. Sorry, they have not been given.
given my
They have only
my
been
instru-
given the pay scale. Pay scale can be the minimum pay scale. It doesn't have to be the highest pay scale. You see, pay scale means say your pay scale is from 10,000 to 30,000. You can either be getting 15,000 or you could be giving 29,000 depending upon the number of years of service you have had.
May I pray your lordship? Your lordship may give us a liberty to approach the authority, and authority will decide within certain time that
That liberty is there, let him go.
that
Because you are a contract employee, you've got nothing here.
my lord, but my lord, when they are taking service like a regular employee from us, my lord, we are in disaster, my lord.
That is why the Supreme Court has said that you can get the minimum scale of pay. You cannot get,
Minimum
you
As
can
per
get the
my lord,
minimum.
7th pay, I am entitled for minimum that pay scale of 30,000 to 1,10,000. That pay scale. Your lordship.
You ask them, you ask.
We will approach the authority.
What is the pay scale of a field officer? Tell me.
They are giving my lord 2 lakh 40.
No. What is the pay scale given to a regular field officer?
That is under 7th pay scale, my lord. This 7th.
It's a council. You see, I'll just tell you. These cases that we refer to pertains to, say, a peon. There are some peons on muster roll, there are some peons on fixed pay, and there are some regular peons who get a pay scale. So it was in that context.
Field
That the-
officer, my lord, it is not yet to be.
So just listen. So it was in that context that the Supreme Court said that just because they are muster roll or fixed pay doesn't mean that they should get less than those regular peons. Accordingly, they should be given the same pay scale, but the minimum. The minimum pay. So, but that will be higher than their fixed pay. So it is in that context now why this court is asking you, since you are a field officer on contract basis, is there any regular sanctioned post of field officer in the government?
No.
Then how are you going to come?
That's why, my lord, we are approaching. We have been appointed, my lord, in the year 2017, your lordship.
Maybe, but then you have got to say that your pay scale has to be equivalent to this pay scale.
My lord, because in the 7th pay commission, it was recommended, my lord.
For field officer?
My field officer.
Where is that?
My lord, in fact, it is not there, but
if it is not there, how do we know?
Honorable Minister is writing, my lord, that it has to be.
Honorable Minister will write a lot of things.
So that this is if your lordship not.
In fact, the ministers of the government in our state have promised a lot during election time.
True, my lord, but here, my lord, this is the official communication given to learned, my lord, Chief Secretary. So far as field officers.
These have got no force. These have got no force. These are not government notifications.
My lord,
Government notifications have to be issued under Article 162 161.
May I pray if your lordship may take up
Lordship may
tomorrow,
carry
my
it
lord?
No, 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 nothing,
In
nothing
that
like
case, your
tomorrow.
lordship may dispose
I
it of-
dismiss it otherwise.
not dismiss, my lord. I may be
Lordship,
given liberty to approach the
Let
office,
him approach.
my lord, and your
Lordship may
authority will
kindly
decide.
turn to the page 49, Lordship.
Okay. Yes,
There is nothing mentioned about the field officers, my lord. How
correct,
they-
that's what.
That's why we are saying you have given to others. Why we have been deprived? I am saying that. That's
But
why
Mr. Council, one thing, why they are saying this, is that they are governed, their service condition is governed by a contract.
contract.
Then,
I am not wrong, my lord. My
then unless you challenge your terms of your contract,
I am not
and
wrong.
if you challenge, then you're nowhere.
I am on that, my lord, since they have given to others in disaster management department, my lord. Why I've been deprived, my lord? Since your lordship is not inclined, my lord, so in that case, I am praying your lordship may give me liberty. I will approach and authority will decide within a certain time frame.
No, that will.
My lord. That much, otherwise, my lord, this issue is pending before this honorable court,
I doubt,
my lord. A number of,
I doubt.
my,
How can, even if it is pending,
My-
you've got no enforceable legal right.
I may not be.
I
able
can,
to
you see, there's no point keeping your case pending
My lord.
when this court doesn't find any ground.
I was under the impression, my lord, since today, the first day. Otherwise, my lord, I could have. my lord,
The first day is the most important day.
Through your lordship.
Either
So
you,
I was- since-
either you have a case or you don't have a case.
My lord, since this honorable court had already seized with the matter, so I was under the impression your lordship will also.
Where have you said in your writ petition that there are similar matters pending?
On 10th, my lord, on 10th of
Anyway,
this,
right. Heard Mr.
A. Goyal, my lord.
A. Goyal, learned counsel for the petitioner, who submits that the petitioner was appointed on contractual basis for a period of 1 year under the Assam State Disaster Management Authority (ASDMA), subject to renewal upon performance of the appointee on a fixed pay of rupees 240,000 per annum. The petitioner case is that there have been several meetings and resolutions passed by the
State level committees,
by the various departments, is it?
state level committee and state disaster management,
By the state level committee and
state disaster management,
state disaster management
my lord.
department,
Management department, authorities, my
management authority,
lord.
authority to better the service conditions of the petitioner who is holding the post of field officer in ASDMA. Full stop. The petitioner's counsel submits that the petitioner should be given pay scale as per the revision of pay, as per the 7th revision of pay rules. 2018 or what? No.
7th Assam Pay and Productivity Commission. 17.
As per the 7th
Assam
revision of
Pay and
Assam
Productivity
Pay and
Productivity Commission.
Commission. That's all. Rules, 2017. That is pay scale from that is the pay scale of rupees 30,000 to 1,1110 1,10,000. Huh? He submits that in this regard, the Minister Revenue and Disaster Management Assam, white letter dated 8/6/2023, had requested the Chief Secretary Assam to make necessary arrangement for sanctioning the non-sanctioned posts of field officers (DF) within ASDMA with an ideal salary structure. However, the same has not been done till then. Next paragraph. The Petitions Council also submits that the State Executive Committee of ASDMA in his 24th meeting at agenda item number 6, held on 26 to 2016. And as per the concurrence issued by the Finance Department, had allowed some employees of ASDMA,
57 number.
who are not field officers, to get the benefit of the corresponding pay scale of the 7th Pay Commission with effect from 1/4/2018 till their contract, till the tenure of contract was in force. So we submit that the petitioners should also be given the same benefit as provided in the order dated 29/4/2019, issued by the Commissioner, Secretary, and Chief Executive Officer, ASDMA. Next para, Mr. A. Goyal, the learned counsel for the petitioner, submits that the writ petition can be disposed of if the petitioner is given the liberty to file a detailed representation to the
Respondent number 2 and 3.
respondent number 2 and 3. For getting the benefit provided to the employees mentioned, to the 57 employees mentioned, 52 employees mentioned in the order dated 29/4/2019, issued by the
Commissioner,
respondent number. He is not here.
not here. Chief Executive Officer, Assam State.
Issued by the Commissioner Secretary, and Chief Executive Officer, ASDMA. Next para. Mr. Yes, who is there?
I am for respondent number 2, 3 and 4.
Mr. J. Handik, learned counsel for respondent number
2, 3 and 4.
2, 3, and 4, Mr. R. Dar for respondent number 1, and Mr. P. Nayak for respondent number 5. 5 submit that they have no objection to the prayer made by the petitioner's counsel. On considering, now, in view of the consent of the parties, this writ petition is disposed of, with liberty being given to the petitioner to submit a detailed representation to the respondent number 2 and 3 with regard to their grievance. In the event the petitioner submits his representation to the respondent number 2 and 3, it is expected that the respondent number 2 and 3 shall dispose of the same within a reasonable time,
Time frame may be 2 weeks.
and preferably within a period of 2 months from the date of receipt of a copy of the order. Full stop. Whatever I said, no. So submit that there is no objection to the prayer of the writ petitioner. Though they submit that the petitioner has no enforceable right with regard to his grievance. That's not.
Lordship, item number 12, 13, 14, 17, 18, 19, 22, 23 and 24 are similar.
Okay, see.
Item number 11 to 14, 17 to 19, and 22 to 24.
Uh, 12, 13, 14, 17, 18, 19, 22, 23 and 24.
Deeply alright.
Oh.
No, but one thing, okay, yes. But one thing he has to be given the minimum pay scale, that much, it appears.
In my understanding, Lord, this is minimum pay scale and the corresponding course. That is the course that has been given. Technical upside is not there.
That is why. It appears there is no corresponding force.
Basically, this is the contribution.
Yes. Item,
May I please, your lordship? Item 15, my lord. My lord, over here, crux of the matter is that though you were appointed in the year 1994, ultimately, my lord, because of the excess post appointment and appointment against non-section, all this cropped up between 91 to 2000, my lord. And in the year 2012, the government has taken a decision of the screening the entire appointments made that year, the 10 years, my lord. In 2015, the decision of the screening committee came, and ultimately 2020, we have been accommodated. But the fact remains, my lord, we have been accommodated under the 2017 Act, which is exclusively for venture schools. We are not working in a venture school, nor we are appointed as by the managing committee. We were appointed after the subdivisional advisory committee's selection, and we don't cover under the 2017 Act. And because of the 2017 Act, now we have been treated as tutor, which is, my lord, we are not getting the minimum wages. The salary is not even covered by the Minimum Wages Act. My lord, in this respect, 2 writ petitions already filed earlier. Notice of motion issued and 4 weeks time given for returnable, my lord. Earlier, this petition was approached, but the cabinet memorandum was not in us. And from the other side, it came, my lord, the cabinet memorandum is not under challenge. So this honorable court, after considering everything, then gave us the liberty to approach challenging the cabinet memorandum. So we have challenged the cabinet memorandum, which is Annexure 7. My lord.
what are you praying for out here?
My lord, to give us the benefit as per the 1977 rule, because we are not covered under the 2017 rule, which is exclusively for venture schools, my lord. And 2017, prior to 2017 rule, our A screening committee already took a decision regarding our appointment and everything in 2015. 17 rule came later on.
No, what do you want? What are you paying for?
My lord, scale of pay, my lord,
Why?
as
On-
per 2017 rule and or the
As per 2017 rule? You said that
2000
you're not appointed as
No,
per
no.
2017
no
rule.
2077 rule, 1977 rule. We are covered by under 1977 rule.
You pay a scale of pay since when? From when? From which period do you want the scale of pay?
From the date of accommodation, my lord,
When?
2022 with effect from 2021.
When were you appointed to the post of tutor?
My lord, we were appointed by page 72, my lord.
Yes.
My lord, page 72. This is an Annexure 5 series in respect of all, my lord.
Yes.
My lord, in middle of the thing, just before the bold letter tutor in LPUP, the following candidate is hereby accommodated as tutor in LP/UP school purely temporary basis on fixed salary of so and so, my lord.
Yes.
This cannot be done, my lord.
Why?
As per the Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institution Act 2017. My lord, now, if your lordship takes the just preamble of the 2017 Act, my lord.
Is this against the regular sanction post? Let us see the act.
Yes, my lord.
Which act is it?
My lord, 2017 Act is, my lord, in this book. In this book, page.
I do not know what you want.
My lord, page 101, your lordship got it.
Page 100
101.
Yes.
My lord, preamble.
Yes.
Whereas it is expedient to provincialize the services of the teachers of the venture educational institutions.
Mr.
And-
Counsel, are you claiming from when are you claiming your pay? From which year?
My lord, this accommodation, from the accommodation, my lord.
From the date of accommodation?
Yes, my lord. We deserve it, my lord.
Then this is with regard to provincialization of venture education
Yes,
institution.
my lord. We are not provincialized.
Huh?
We are not under this act. This act has come 2017.
Huh.
We
So-
were appointed in the year 1994.
So
The government has taken the decision.
now you're coming to the question here. So you want so 1994. So you want pay scale from 1994.
No, no, no.
Then?
What I'm saying, in 1994, when I was appointed, that time the 77, under the 77 rule, this 2017 rule was not in existence.
Correct. But then was your appointment as per the 1977 rules? Was it a valid appointment?
My lord, appointment.
Was it a valid appointment?
Yes, my lord, appointment was a valid
Then you
appointment.
please come to page 118, 119. This is your petition, I believe, page 119.
Yes, my lord.
Please come to para 22.
Yes, my lord.
Please read.
My lord, before that, can I go to
Please read this first.
page 20?
Yeah, please read this, then we'll go wherever.
It is well settled that any appointment made in excess without advertisement against any non-existent post cannot be termed as valid appointment as provided under Article 14 and 16 of the Constitution of India. And the case of the petitioners are under the category of excess appointment and or appointment against non-existent post.
And the case of the petitioners, who is the
Yes.
petitioners?
We-
Here. Yeah. So don't talk about 1977, that is gone, finished. Your appointment in 1994 has been declared by this court to be under the category of excess appointment and against non-existent post, and it is not a valid appointment. Now, has this order been challenged by you?
No, this the,
Then,
my lord, this,
now, so that aspect goes. So you cannot go back to the 1994 appointment. That is all invalid appointment. So that issue is gone.
my lord, what I'm saying, this order, if your lordship looks at the last part, my lord.
Yes, yes.
Last part. Over there, when we approached, we did not challenge the cabinet memorandum which said it
No,
is
no,
17.
Mr. Counsel, the cabinet memorandum, you challenge it or do not challenge it. The fact remains that this court has held that the appointment has been made in excess without advertisement
Yes.
and against non-existent posts. So whether you challenge the cabinet decision or do not challenge the cabinet decision, the fact remains that this finding of the court has attained finality as on date.
My lord, would your lordship-
That with regard to the challenge to the cabinet decision, that is an added ground, that's all.
would your lordship be pleased to see the page, para 20, my lord?
Yes,
That was our case. And my lord, this, it is well settled. This is the expression of.
it was your case,
Yes,
but the court has added some more.
some more, yes. See the para 20, my lord, that was our case, my lord.
You go and review against this order if you say find that this observation is incorrect. Now, this will always stand in your way with regard to your claim for getting a pay scale in terms of the 1977 Act.
My lord, this, if your lordship looks at the last paragraph,
Yes,
that liberty to approach challenging that cabinet decision.
correct,
That is the reason.
correct. But the fact remains that para 23 does not take away the findings of the court made in para 22.
My lord, another aspect, I'll just put forward with your lordship's appreciation. My lord, it is well settled that ultimately, whatever it is, they have to give us what we, so the normal teachers are getting this much. As your lordship just now, I think prior to this case, the minimum they should give us. And if your lordship looks at the cabinet memorandum, that page 104. 104, once.
Yes,
My lord, the views of the judicial department
yes.
in respect of this category of teachers, there were about 3,000 teachers were.
You see, this is all water under the bridge. Okay, that is a closed chapter now, because for the simple reason, you have to get past the hurdle of the finding of this court in para 20. Unless you go past that hurdle, whatever might be written here, because these views of the judicial department and all, I think will pertain to
In respect of minimum,
tutor,
in respect of minimum
minimum pay scale.
salary under the under the Wages Act, my lord,
Ah,
that is also not given in this case.
no, is there any tutor, any regular sanction post of tutor?
Under the 2017 Act, yes.
Yeah. Then you'll get the minimum of that, that's all.
No, my lord, under the what I'm saying, 2017 Act came as far as if the 1977 Act is concerned. 2017.
But you were not, now you were appointed as tutor in terms of what act?
2017 Act. That cannot be.
And, but you were appointed when? When did the 2017 Act come into force?
2017 itself,
And when were you appointed as tutor?
2021.
Then what is wrong?
But basing on the decision of 2015.
So what? 2015, but that now has the 2017 Act repealed the 1977 Act?
No,
No, okay, not repealed.
it does not repeal. It is independent only in respect of the venture schools where the schools have been developed by the people. The appointments are made by the managing committee. In our case, after the subdivisional committee selected us, we were appointed. Then they came to the finding that there were excess posts. Ultimately, the government went for screening in the year 2012. 2015, they have come with a decision that this much of teachers we can accommodate. Ultimately,
So you are excess teacher.
yeah, we access teacher.
Yeah.
So 2015, the decision took place. They did not do anything. Ultimately, in the year 2022, they have given us the appointment taking the with effect from 2021. But in the meantime, they have tried to tag us with the 2017 Act, which is not even applicable to us at all because we were not appointed by the managing committee, nor we are part of the venture school. We were in the government
No,
sanctioned school.
but the earlier appointment all goes. Earlier appointment all goes because the earlier appointment is an invalid appointment.
Yes, yes.
Then-
My lord, if it is goes also,
Then-
for example, for argument's sake, if your lordship takes it, earlier appointment goes, but they did not give us fresh appointment. They have accommodated us in response to the earlier appointment. If they accommodate us, still they cannot give us appointment under 2017 Act because that act is exclusively for provincialization.
Let us see this. You have been appointed as tutor on the basis of which advertisement?
Nothing.
Then that appointment is also illegal.
Yes. But that is because of the cabinet decision in respect of earlier excess teachers and excess teachers as well as appointment made against the non-sanctioned post. Ours was considered as an excess teacher. My lord, did we have any hand in that in the year 1994?
No, whether you have a hand or not, the problem is, the issue now is, this court has held that the petitioners are under the category of excess appointment and or appointment against non-existent post.
Yes.
So then your
Yes.
appointment there was illegal.
Yes. After that, my lord, after that, the government has taken up the decision to screen out everything in the year 2012. They took 3 years. In 2015, the screening committee report came. But this act is, my lord, exclusively for provincialization of venture schools, where appointments are made by the managing committees of the schools.
2017,
17,
only for venture school.
only for venture
And
schools.
you have been appointed as a tutor in a non-venture school.
Yes.
So you want a pay scale.
We want the pay scale
From
because-
the date you are appointed as tutor.
Yes. We cannot be treated as a tutor because tutor is in the venture school. 2017 Act, the term venture came.
Aja, you cannot be appointed as a tutor.
We cannot be.
Then you cannot be. Where do you stand?
We should be a normal teacher
On what ground?
because
Without advertisement.
no, we were earlier
Yeah, earlier is gone.
No, what I'm saying, earlier advertisement was there. We were selected.
No,
we were
no,
appointed.
earlier advertisement not there.
Yes, it was there.
This court has held at para 22. It is settled. It is well settled that any appointment made in excess without advertisement.
My lord, but our appointment is made after the advertisement, as far as we are concerned, after the advertisement, there was selection process. In that selection process, our name came, we were appointed. Then it was held. We even got the salary. Then suddenly
Anyway,
it was
right.
held.
Yes, anything to say?
Yeah, Malak, they have been appointed as tutor because they have not the required qualification.
They don't have the required qualification
what-
for. Oh yes, that is there.
They cannot be appointed as assistant teacher. Malak.
Yes,
They have
yes.
not the required qualification.
Yes.
They have not been appointed under the 2017 Act. They have been given the pay under the 2017 Act, my lord, because tutor post created under the 2017 Act. Those who doesn't have the qualification, they have been appointed as provincialized as tutor in the 2017 Act, my lord.
Yes, yes, I read that somewhere.
It's because of the namesake, my lord, nothing else, my lord. Since they do not have the educational qualification, that is why they have been accommodated as tutor, my lord.
No, no, it is stated somewhere, yes.
In the order, my lord,
Yes. The petitioners herein belong to the second category, yes. The second type of teachers without having the requisite educational training were appointed as tutors.
that
So
is the
the
reason, my lord.
teachers without having the requisite education.
Paragraph 14, my lord.
Yes. So
My lord, at this stage, what I would say, that part I have already said in my repetition, that a man who is about 59 years already age, 57, 56, they are not able to get that qualification now. When in the year 1994, that qualification is not required, because there is a government OM 23/8/2010, where it says any appointment prior to 3/9/2001 need not have higher educational qualification. We are covered by that.
no.
Yes, my
So
lord.
as per the 2000, Mr. Khataniar,
Yes,
as
my
per the 2017 Act, they are supposed to have this educational training.
Yes, my lord.
Of normal.
This is NCT regulations, my lord.
Right. Huh? Page 106 of the writ petition. Yes.
So whatever they pay given from the act of 2021, if they are agreed, and that means they will.
My lord, this notification is exclusively for 2017 Act only, not for us. It's 2017 Act. That's what I'm saying. I'm not covered with 2017 Act.
Why?
2017 Act is exclusively for provincialization and provincializing the teacher who are working in a venture school. It is not that I have been accommodated against a venture school.
No, you see, the case is quite simple. Unless you are appointed on the basis of an advertisement, the appointment is illegal. Now, the earlier appointment made in 1994, the court has held that it was illegal. That has attained finality as on date. That has not been challenged in review by you. So when it has now, the subsequent appointment of you as a tutor is also basically illegal, as there's no advertisement. It has been made in accommodation, though your earlier appointment was invalid. So where do you stand?
My lord, I will just take your lordship to one case, my lord. Earlier, this writ petitioner approached this honorable court when earlier, my lord. Page 68, my lord.
Yes.
My lord, in response to this judgment only, legal, illegal, irregular, regular, all the decision was asked to be taken by the government. And then only the government took the decision.
Correct.
Yes, ma'am. So over here, it was in respect of those appointments made in the year 1991 to 2001.
Which includes you.
Which includes us. So we are within that act which is prevailing as on date and as was on that time.
At that time, yes.
1977 rules still is prevailing. My lord, the minute what I'm saying, your lordship, I'll just, your lordship may appreciate one thing. Under 2017 Act, the Provincialization Act, the day school is provincialized or the teacher is provincialized, he automatically transfers himself to the 77 Act.
Correct.
the 2017
When
Act
he's
doesn't,
provincialized.
yes, 2017 Act doesn't remain. So 2017 Act is what? It is a one-time measure in respect of the schools which are venture in nature, teachers appointed by the managing committee. Only for those. The minute they are provincialized, that part is gone, my lord, in respect of the provincialized teachers. And what I'm trying to approach, I don't know, I may not be successful in putting the words, my lord. What I'm saying, in no way I can be put under 2017 Act, because neither I am appointed against a venture school, nor I was appointed in a venture school, nor I have been appointed by the managing committee of that school.
No, so if you are not appointed as per the 2017 Act, how can you say that you are appointed as per the 1977 Act when there is no advertisement? I know, government took a decision to accommodate them. Now if, huh?
2020,
Yes.
the decision was taken by the government. And when the decision was taken, at that point of
Hmm?
time, the 17 Act was amended.
17 Act,
77 Act was not really on that day.
77 Act is still in force.
No.
It's repealed.
77 Act, definitely.
Okay. On that day, Lord, when the decision was taken, to accommodate their thought. It was in terms of 2017. That is the number.
No, my question is the 77 Act still in force?
Yes.
Yes, madam.
Is it
Yes.
force? And 2017 Act is there
Yes,
also.
77.
Now, 2017 Act is for what purpose?
It is for the purpose of provincialization, my lord.
For the purpose of
Yes, madam, it
provision.
is for the purpose of provincialization. But the nomenclature tutor, that is derived from the 17 Act, my lord. Nothing
17
else, because
There is no tutor in the 77
77
Act.
No.
There is no tutor in the 77 Act, but since they do not have the requisite qualification, and in the 17 Act, my lord, the tutor nomenclature is there. Those do not have the requisite qualification. That is why that nomenclature is derived from the 17 Act, nothing else, my lord. They have not been accommodated under the 17 Act, but the nomenclature tutor is derived from that Act, my lord. In fact, my lord,
Anyway, so they have been appointed as tutor.
Yes.
In a venture school or a non-venture school?
non-venture school, my lord, because
Non-venture school.
they are working in a government's provincial school, my lord.
Venture
And
school.
since their initial appointment was
But the provincialized school will not come under the 2017 Act. It will come under the 77
yes, my
Act.
lord, yes.
So government has made a mistake also. But
Well,
even
can you
that,
see-
but where is the right of the petitioner? I still don't understand.
My lord, kindly
My lord,
see their appointment order, my
The
lord.
question my lord put it, my lord, would your lordship be pleased to see the paragraph 3, page 9? My lord, I don't want to say much about that order which your lordship is relying. That was on the motion stage. After a deliberation that I did not challenge the cabinet memorandum. When I did not know the cabinet memorandum was, the other side said there was a cabinet memorandum that is not challenged. Learned Single just took that view and ultimately that order was passed on the motion day itself. Well, para 3, my lord. Have your lordship got it? Page 9.
Yes.
My lord got it. That the petitioner have to state that they being eligible participated in the selection process pursuant to an advertisement dated 3/9/91 for the post of assistant teachers of upper primary school. I am being selected by the subdivisional advisor.
No, you see, these issues again, you see, unless you make a challenge to para 22, your earlier appointment is of no use. It's an invalid
My
appointment.
lord, that was what I'm saying. It was what happened in Assam. My lord, lots of appointments were made even without advertisement. It was a general.
But anyway, now that what has happened. Now this order is here. This order at page 119
92.
categorically speaks of your appointment done in 1994 as being invalid. So unless you make a challenge to this order,
Perfect.
this that portion is gone, finished.
Yes, my lord. What I'm saying, my lord, now from the date of accommodation, though the accommodation for the screening committee decision was in the year 2015, They were sitting idle.
Huh.
And because of that, the division bench said, no, now you take the decision. 2018, which I just relied, my lord. In pursuance to that, in the year,
Where 2018, where? Which decision?
this division bench decision, my lord,
What?
page
Yes,
68.
yes.
This is the, my lord, filed by the state, my lord. Your lordship seen it, my lord. This, if your lordship looks at the page 71, this history is coming from 2004. My lord, page 71, last paragraph.
Yes,
If your lordship seen it.
yes.
As already indicated in our order dated so and so, we are of the view that on the basis of the recommendations of the committee, it is for the government of Assam in the elementary department to take necessary steps, decisions in terms of the order dated so and so by which so and so was disposed of. These recommendations of the committees came in the year 2015. And ultimately 2018, when this honorable division bench of this honorable court passed this order to take the decision in the light of the 2010 order for which they were not taking, ultimately they took the decision. And decision, my lord, accommodated us, not only me. The accommodation was in respect of around 4,000 people. And my lord, interestingly, another aspect, my lord, all the 4,000 people were not tutors.
You're not tutors. Anyway, but then what to do? We have got to now. You want pay scale as
Well,
tutors, correct?
I will say another exactly on the same matter. Two cases are pending, my lord. On last 13th 10, I have filed, got the notice of motion. One is 6042, one is 6061.
So,
Same matter.
so
So your lordship may issue the notice at this stage. Let all the cases be decided together, my lord. It is nothing. They will get only few. They are working after 20 years of free service, getting the appointment. Now they will get some salary. That is all, nothing else. That is the minimum. If your lordship takes the minimum wages,
just a minute. Right, heard Mr.
yeah, within my lord.
Jayabidin learned counsel for the petitioner who submits that the petitioners were initially appointed as assistant teachers in different upper primary schools by an order dated 28/2/1994. However, as their pay had been stopped, comma, the petitioners had approached this court. Correct? You had approached this court along with others.
Yes.
Along with
A few of the petitioners.
along with a few of the petitioners had approached this court along with others. The stand of the state government in stopping the payments made to some of the teachers was on the ground that they had been appointed. That was on the ground that the appointments were invalid as they were appointed in excess and against non-existent posts. After no, full stop. Thereafter, on the basis of orders passed by this court, comma, the government made a verification of the appointments of teachers and categorized three types of teachers. Comma. One teacher, no, number one, that page para 11, page 117, huh? 1, 2, and 3. Para 11, 1, 2, and 3, huh? The petitioners were bracketed as those teachers who did not have the requisite educational training. So on humanitarian grounds, you were appointed basically. Humanitarian.
Yes,
grounds.
madam. In fact, it is reflected in the cabinet decision.
It
madam.
appears that on the basis of a cabinet decision and on humanitarian grounds, comma, the petitioners were appointed as tutors in provincialized schools,
Accommodated.
were accommodated, were appointed, were being appointed, it says being appointed, huh? Were accommodated,
Yes, my lord. The language is accommodated.
are accommodated in provincialized schools. In terms of the Assam education bracket provincialization of services of teachers and reorganization of educational institutions bracket close Act, 2017. Yes, sir. While orders dated
My lord,
30th January
30th
2021.
January 2021.
31/01/2021. The petitioner's case is that they could not have been provincialized, they could not have been accommodated as tutors in terms of the 2017 Act, but would have to be accommodated in terms of the Assam elementary education bracket provincialization that close rules, 1977. Here and after referred to as the 1977 rule. The petitioner's case is that as they were teachers since the year 1994, they would have to be accommodated as teachers in terms of the 1977 rule. Issue notice returnable in 4 weeks. Mr. N.J. Khataner accepts notice on behalf of
Madam, 1, 2, 3, 4. 1, 2, 3, and 4, madam.
1, 2, 3, and 4. While Mr.
EW4, respondent number 6.
We really accept notice on behalf of number 6.
5 P Nayak, madam.
Huh?
For
Mr.
5,
P.
madam,
Nayak
P.
accepts notice on behalf of number 5. 5, no?
5, madam.
So from next, right? A perusal of the writ petition shows that the petitioners had approached this court by way of WPC 5128 of 2023 and para 22 of the said order dated 8/9/2023 passed in WPC 5128 of 2023 shows that the appointment of the petitioners as teachers in the year 2000, in the year 1994 had been found to be invalid appointments, as the petitioners had been placed under the category of excess appointment and / or appointment against non-existent posts. Further, their appointments had been made in excess without advertisement. Full stop. In this respect, comma, we would have to keep in mind the judgment of the apex court in state of Orissa versus Mamata Mohanty, 2011, 3 SCC 436, where the apex court has held that appointment in the absence of any advertisement is illegal as it is violative of Article 14 and 16 of the Constitution. Full stop. Thus, keeping in view para 22 of the order dated 8/9/2023, passed in WPC 5128 of 2023, it is clear that the petitioners cannot have any right in pursuance to their earlier appointment in the year 2000, in the year 1994 as assistant teachers.
My lord,
Full stop.
would your lordship point out this? What your lordship has, because paragraph 3, I must probably I'll go for a review with paragraph 3, my lord. So this sentence may not be given, my lord.
No, you have to go for a review, we'll close the case. But then we'll have to reflect this part.
Okay, my lord, continue.
Huh?
Continue. Your lordship may continue.
Yes. What did you say? What did you want actually?
What I said, like regarding
Huh?
regarding our earlier appointment without advertisement.
But this is reflected here, no?
What I'm saying,
Para 22.
my lord, this was a general in respect of all, not for this petitioner.
No, but then it says here, and the case of the petitions under the category of excess appointment
Yes,
or appointment against non-existent post.
excess and non-existence can be also happen with advertisement also. In our case, it happened with.
Okay, so even if we say that even if we cut off that part of advertisement, but since you are appointed against a non-existent post, then that is a legal appointment.
That will remain.
That will remain. Then
Okay, then I leave it to your lordship.
you want me to cut that advertisement part?
No, it's okay, it's okay.
Yeah. Whatever. As teachers, as assistant teachers, as they had been appointed against non-existent. The only issue is with regard to whether they should be given a pay scale as tutor. From the date of their appointment as tutor.
Well, the issue is whether I deserve the pay, fixed pay as tutor under 17 Act or regular salary under 77 rule. That is the one.
What about that? As tutor, in terms of
In terms of
the 1977. But not in terms of, in terms of 1977, but not in terms of the 2017. But not fixed pay in terms of the 2017. Correct? Full stop. However, to this, Mr. N.J. Katania submit that there is no post of tutor mentioned in the 1977 Act. And the post of tutor is present only in the 2017. This is the matter of study.
Okay.
As this is a judicial order, my lord, what my lord has pronounced. I think in the last part regarding that only case of the petitioner where if my lord has said, I think the word tutor may not be there. Because if I'm asking for 77, it's not tutor.
Then that's what, you see, if you're asking for 77, now what are you asking for, as what?
Regular salary under 77.
As per what? As what? As what? As a chakidar, as a
Not
teacher,
as
as
a
what?
teacher, as a teacher.
How? Because that is why your case goes, because there is no post of, your appointment as a teacher has been, held to be illegal by the court.
After the accommodation by the, in view of the cabinet memorandum,
I've clarified that, then your case goes, you've got no case.
okay, madam.
You
If you-
you file a review. I'll clarify that, huh? Whatever I said, just read the last paragraph. The only, no, the issue raised by the petitioner is that, he should be given the pay scale given to a teacher in terms of the 1977, and he cannot be given the, the fixed pay of a tutor in terms of the 2017. Full stop. The above stand of the petitioner would have to be clarified in as much as this court in the order dated passed in WPC has held that the appointment of the petitioner in against non-existent post in para 20 makes their appointment as assistant teachers invalid. And the same, further, the same has attained finality as something, has no challenge to the said finding has been made by the petitioner. You clarify on the next day. You have got to go in review against that past process. There's no other.
Please, the matter that the claiming one advance estimate to the petition.
Item,
Claiming one advance estimate to the petition on acquiring her PhD degree. Initially, she was appointed to the post of assistant teacher 1993. Later on, she was deputed to undergo a B.Ed course project.
have you filed any representation for this?
No, it's verbally approached to the responsible person.
Verbally approached?
Yes. This is a covered case. Earlier, group of teachers.
Yes, Mr. Katania. Please go through it.
Only to verify the statement.
Just a verification.
So let it be verified, and if there is, let us. Okay, right, third Miss
Please, sorry.
Saharia, learner counsel for the petition. Who submit that the petitioner who submits that, in terms of the letter number GB-EST/B ED increment /1/2016/41 dated 21/7/2016, page 22, issued by the Joint Secretary of the Secondary Education, Assam, which is addressed to the Joint Director of Secondary Education, Assam, all assistant teachers are eligible to get one advanced increment for acquiring B.Ed degree, provided number one, he/she has joined before 3/7/2012. Number two, obtained B.Ed degree from UGC recognized university and NCTE approved PhD. The petitioner's counsel submits that the petitioner was appointed as assistant teacher in the year 1993 in Morrigan Town High School by the respondent number. And in the year 1996, he was transferred to Jackie Chai, Jackie,
Jackie Sakilo.
Jackie,
Jackie Sakilo.
Jackie High School. The petitioner successfully completed her B.Ed course in the year 2019 from Government Shikshan Mahavidyalaya, Nagaon, on being deputed by the respondent number 3 to undergo the said B.Ed course. By order dated 30/5/2007. The petitioner's counsel submits that the petitioner is entitled to one advance increment for acquiring BBA degree. So he also submits that the present writ petition can be disposed of if a direction is issued to the Director, Secondary Education Department to verify the claim of the petitioner as to whether he had obtained the B.Ed degree from a UGC recognized university. If the claim of the petitioner is found to be correct, the respondents should be directed to grant one advance increment. So in this respect, he submits that a similar case, that is WPC number 6607 of 2021 had been disposed of by order dated 2/8/2020. He has accordingly paid for a similar order. Next, Mr. N.J. Katane, Learned Counsel for the for
For account number
for
134.
134 and Mr. P. Nayak for respondent number 2 submit that they have got no objection to the prayer made by the petitioner's part. In view of the consent of the parties, the present writ petition is disposed of with a direction to the Director, Secondary Education Department. Secondary Education Department.
Yes.
To verify the claim of the petitioner as to whether he has acquired B.Ed degree after joining her post subsequent to P7/2012. If the director comes to a finding that the petitioner had acquired B.Ed degree from a UGC recognized university and NCTE approved B.Ed college, the claim of the petitioner, the petitioner should be granted one advance increment in terms of the letter dated 21/7/2000 issued by the Joint Director of Secondary Education, Assam. The entire exercise should be undertaken by the respondent within a period of 2 months from the date of receipt of a copy of this order. That is petition accordingly. Sir, who was supposed to take the instruction? Mr. Gogoi, I think, no? Gogoi. Where is he said at two, he
Number one, we will consider it, but we will give us some time. Can we discuss? They will pass it quickly.
when?
4 weeks.
Why 4 weeks? He's in a hurry. This case has been filed. My God, this case has been filed in September. September, October, 1.5 months have gone.
Reasonable time will be given. From the date of receipt of certified copy of the order date. It will be 2 weeks or 2 years, 2
So we tell them to take a decision within 10 days.
2 weeks.
2 weeks.
And it is, after 2 weeks is too long matter because if you ask it before they have already taken matter. It's simple matter. So far I know the inspection has been received from the Deputy Commissioner, Deputy Commissioner Court. I was informed by my client that the inspection has already been sent. The government has so, without observing anything on the merit lot, you will only directly consider
But he wants a short time. How long will it take?
2 weeks, my lord, that is the outer limit. It's not that they will wait for the 14 days to take it.
Usually 2 weeks is not enough.
I will convey,
Huh?
I will convey.
You're right. Heard Mr. K. Sharma, learned counsel for the petitioner, as well as Mr. P. Gowai, learned counsel for the
Recorded 1 minute. Yes.
point number 1. Mr. Correct. Appeal point number 2. The petitioner who is working as lower division assistant. Lower division assistant. Huh? Working as junior district administrative assistant, is it? What are you working as? Who's working as junior district administrative assistant in the establishment of the district commissioner where? Huh? Parpita. Seek transfer to the establishment of the district commissioner Biswanath. Correct?
Yes, of course.
The petitioner's counsel submits that for the finalization of the transfer order to be made by the respondent number 1. Correct? Respondent number 1. Good. Comma. The district commissioner of Parpita and district commissioner of Biswanath have both issued no objection certificate. The petitioner's counsel submits that there is a vacant post of junior district administrative assistant in the establishment of the district commissioner Biswanath.
Yes.
Where the petitioner can be accommodated.
I can see here they have mentioned here.
Accommodated. As such, there should be no difficulty on the part of the respondent number 1 in issuing the transfer order. Next para. Mr. B. Gowai, the learned counsel for the respondent number 1, submits that The writ petition can be disposed of if a direction is issued to the respondent number one to take a final decision on the petitioner's application for transfer within a specified time period. On considering the prayer of the petitioners and the fact that the district commissioners of Vishwanath and Arpita have both given no objection certificate for the transfer of the petitioner to the establishment of the district commissioner Vishwanath, this court directs the respondent number one to take a decision on the petitioner's application for transfer to the establishment of the district commissioner Vishwanath, within a period of within a period of 10 days from the date of receipt of a copy of this order. The writ petition is accordingly disposed of. And before that, you're right. The decision made by the respondent number one should be communicated to the petition. The writ petition is accordingly disposed. Disposed of without making any observation on a major petition. I've not said anything. I've not said anything. One observation. No, I've not said anything. That's enough. Right. Hey, why should we spoon feed every year all the time?
Why, my lord? That part. Because telephone inspection, my lord,
No, how does it?
that all my.
We have not made any observation. You can always.
Public. Yeah, blue lord. But letter pattern to manage temporary retrospective measure. By the order dated 18/9/2023 measure. But the petitioner is reinstated measure on the same order measure. He was temporary attached measure with the district museum measure group measure. There's 41. And challenging the second part.
No, let us see the judgment in that Ajay Kumar. What does it say?
In 14, para 14 is stated lordship that
Any office.
lordship, as in the case of hand, the government is free to transfer the concerned person to any department in any of the officers within or outside the state to as to serve the local or personal contact that he may have and which he must misuse the obstruction that
Lordship, I am ready to permanent transfer. This is temporary attachment.
proceeding is pending.
And
lordship.
And I am also suffering from illness, my lord. Mark, bunch of paper is there.
Is there,
Before the authority.
Mr. Counsel, is there a departmental proceeding in pending against you?
Pending.
Lordship. But we have already inquiry report is already completed, my lord. We have filed our representation against the inquiry report.
Has the evidence been recorded?
Lordship, already all are complete, my
All are complete.
all are
So
complete.
inquiry report has been made or not?
Lordship.
Has the inquiry report been made?
So inquiry report made, my lord. Thereafter, the director is asked for any representation if want to submit. my lord.
Have you submitted?
I have only the submit.
So only decision is required. So let us wait. That's all. You complete.
But I am suffering, my lord. That is why I am.
No, sorry. Are you getting your pay or not?
Okay. Not,
Are you getting your pay, monthly pay?
no, my lord.
Why not?
They are not paying, my lord.
He is not, it is not.
Then we'll direct them that you should be paid your monthly pay. You'll be paid.
They have not paid, my.
You'll be paid now. We'll tell them to give you pay. Where have you asked in your prayer that you should
No,
be
lordship,
paid?
I have not paid.
they are
Then?
not mentioned, lord.
That's why, lord. At the time, my lord, on the same, my lord, same order, my lord, 18/9, my lord.
Where is this impugned order?
18/9,
18/9,
page
lord.
41, my lord. Thereafter, I have filed my requisition, my lord.
In that order, lordship, suspension order was revoked, lordship. It was
Without any reason, I have to suspend my lord. Due to fault of the director, my lord.
That is a different issue. That
Due to-
cannot be
Due to
decided.
I am the only assistant, my lord. I am the assistant, the director
drafted,
Mr. Counsel, please understand one thing. The issue with regard to the departmental proceeding or the subject matter therein cannot be a subject matter here, and it is not even your case. Your only case here is that you could not be transferred to an office where there is no post of whatever post you are holding.
Senior assistant, my lord.
A senior assistant. But then, when you have been given a pay scale, when you're given a pay, and the fact that the entire proceeding is going to be completed because nothing remains, we'll direct them to complete it. That's all. How does it matter? Why should we disturb the apple cart now? Right. Heard Mr. A. Mubarak, learned counsel for the petition. And Mr. A. Chakrabarti, learned counsel for the respondent. Then you take this order dated 27/9/23, para 2, para 3. And in para 3, you continue. He submits. He further submits that the departmental that the only the departmental proceeding has really been completed. In as much as the inquiry report has been made by the inquiry officer, and the petitioner has made a representation against the inquiry report made by the inquiry officer. Next paragraph. Mr. A. Chakrabarti, Bharat State Council, however, submits that in terms of the judgment of the Supreme Court in the case of Ajay Kumar Chowdhury versus Union of India, reported in 2015, 7 SCC 291. Para 14. The government is free to transfer the delinquent officer to any department in any of its offices within or outside the state, so as to sever SEVR any local or personal contact that he may have and which he may misuse for obstructing the investigation against. The government will also prohibit him from contacting any person or handling records and documents till the stage of his having to prepare his defense. In the present case, I have heard the letter and of course, as such, he submits that. No, he submits that though the suspension of the petitioner has been revoked, there is no infirmity with the transfer of the petitioner to the office, to one of the offices of the respondent. In terms of the judgment of the Supreme Court in Ajay Kumar Chowdhury, I have heard the learned counsel for the party. It is not the case of the petitioner that he has not been getting his monthly salary. His only case is that he cannot be posted against, he cannot be posted in an office where there is no post of senior. Be that as it may, the fact remains that the departmental proceeding initiated against the petitioner only requires the decision, only requires the disciplinary proceeding, their disciplinary authority to take the decision on the inquiry report and the reply made by the petitioner to the same. As such, in view of the fact that the departmental proceeding is at its tail end, not the tail end, this court is of the view that this court is of the view that the posting of the petitioner in the office of the attachment of the petitioner in the office of the district museum officer Dubri at this stage should not be disturbed. However, the same would be subject to the final decision to be taken by the disciplinary authority. As the only requirement left for completion of the disciplinary proceeding is the decision taken by the disciplinary authority. The disciplinary authority is directed to take a final decision with regard to the charges framed against the petitioner on the basis of the inquiry report and the reply made by the petitioner within a period of 30 months. 30 months. After completion of the department. Already completed, that's what it says.
Complete by law. My instruction is pending lot,
It is pending at what stage?
not stated lot. That's fine. After 3 months,
Why? You obtain instructions.
no, then 2 months. 2 months. If it is pending lot.
It is pending, naturally. Right?
After completion of the proceeding.
With 45. Reply made on the inquiry report. The subject of 1990,
No, this is different, Mr. Counsel.
no, my lord. Inquiry report, lordship panelist page 36, 37.
Page 37.
37. Inquiry report, my. It start from 36. My.
Oh, yes. What about? To be taken by the the discipline. Comma, on the basis of and the reply made by the petitioner on
99.
on 19/9/23, within a period of 1 month from the date of receipt of a copy of this order. The petition is accordingly disposed of. Okay. So it will depend upon the decision. 1 month to wait for. Yes.
Yes, yeah, I think. My lord, yeah, people, no, my lord,
son and daughter of the deceased, my lord, Jagadish Das, and my lord, the private respondent number, my lord, 12.
First of all, tell me something. Is this petitioner number one a married woman?
Unmarried.
Unmarried?
Unmarried.
Please come to your course title. What is written there?
Juku Prothu Das, is it about 19 years?
Before Jugro Bhatta Das, what is written? Has it been written Srimati or Shri or Mr. or what? What is written?
It is she's unmarried.
Huh?
She's unmarried.
She's unmarried, but then you have written Mrs. Huh?
Typical error.
Typographical error.
Yep.
I don't know. Now we have to go by what you have written. Unless you correct this, how can we say that Mrs. is a unmarried woman?
But we may be permitted to correct it.
How? We cannot allow you by hand. You must have noticed the notification issued by the High Court
Yes.
that handwritten correction not allowed anymore. For the simple reason that it cannot be uploaded into the CIS system. So you have to make an amendment now. It's not like before. If it was like before, we would have allowed it.
Right.
Number two, you want the part of the pension, is it?
Right.
What are you claiming? Only pension or what else?
Not all pensionary benefit.
Huh?
All pensionary benefit.
What is the date of birth of the respondent petition number 2?
Petition number 2. But we have the next thing. My lord, his date of birth, my lord. Okay. My lord, 16/1/2009.
16/1/2009.
9.
Petitioner number 2. Date of birth is 16/1/2009. Okay. Wait. Oh, in that case, when did the father die?
My lord, father died on my lord 14/8/2021.
14/8/2021.
Yes.
2021. Okay. And when did he retire?
My lord, he died during his service.
He died during service in 2021. How old was he?
About his balance service was about my lord, 2 years.
2 years. So in 2021, he was 58 years. Is it? Now, in 2021, the father's age was 58 years, correct? Calculate.
No, my lord, I'm sorry, my lord, the balance service of the my lord, petitioner's father was 5 years.
5 years. So he will be 55,
55.
correct?
Correct.
So 55 years. Now, come to your affidavit. Supreme Court has age 19 years. Huh?
Yes.
Yes, madam.
They may file the IA for the correct.
That is one aspect. What about the merits of the case?
The time may be given, I'll get it.
His case is that they are the children from the first wife.
No,
Correct. First wife is dead or alive?
Right.
So his case is that the pension should be shared.
but the second petitioner is a minor, what they
Ah.
have told.
Yes.
The first petitioner, one aspect is he's married, plus he has a sister is a teacher.
But that marriage part, okay, if married, so she cannot get. But unmarried dependent daughter can get, because of the amendment. And that age mark of 19 years no longer is there. Only for the son it will be.
Also, your lordship,
No. Now it's no more. Now you've got to. That's what I'm saying. There's no age. The section of 21 does not arise. Only thing is that you have made this Mrs.
Yes, we'll file my lord amendment for correct.
also your lordship, the present wife of the deceased, she has already received an amount of six
No.
lakhs.
Yeah, that is all right. But pension, family pension will be a recurring occurrence. So they will be saving that.
Notice may be
Only thing is that you have to make amendment. But I heard Mr. M.U. Mondal, current counsel for the petitioners who submit that the petitioners are the daughter and son of the late Jagadish Das and his first wife, comma, that is, what is the name of the first wife? Bobita Das.
Bobita.
After the death of Bobita Das on 19th 2008, the petitioner's father married the respondent number 12. Correct?
Correct.
The petitioner's father retired as assistant conservator of forest.
Died in harness.
Oh, died in harness as assistant conservator of forest on 14/8/2021. The petitioner's grievance is that despite being entitled to a share of the family pension and other pensionary benefits of their late father, they have been denied the same. And the entire family pension and pensionary benefit is being given to the respondent number 12. Issue notice returnable in 3 weeks, 4 weeks, 4 weeks. Miss
and qualified.
M. Kalita accept notice on behalf of
One is 2, 3, and 4.
2, 3, and 4. Mr. S. R. Barwa accept notice of behalf of 1, 5, 6, and 7. Mr. R. K. Talukdar accept notice on behalf of point numbers 8, 7, and 8. And 9 also. 9 is finance. Now, who will be? Mr. P. Nayak accept notice on behalf of point number 9 and 11. Petitioner to take steps for service of notice upon the respondent number 12 by registered post within 3 days. Next para, you're right. Mr. No, the counsel for the petition I have seek a clarification with regard to whether petitioner number 1 is a married lady or not. In as much as he has been shown to be inverted commas Mrs. Yugo Brotata. Jugobrota. This is the matter of the point.
Apply.
Obliged.
Yes, the case, the petitioner's case is that no final pension is being given or pensionary benefit. On the ground that the criminal case that has been registered against him is still pending and no final report with regard to the same has been made even after a number of years. Huh? Appeals action, right? No one appears for the petitioner. The case of the petitioner is that due to falsification of the petitioner's date of birth, this poor PS case number 1051/16 under section 420/468 IPC was registered. The petitioner retired from service on 30/09/2015 on the state respondents having accepted the date of birth of the petitioner as 8/9/1955 instead of 8/9/1957. The issue of recovery of excess salary paid to the petitioner was decided by this court in its order dated 14/2/2019 passed in WPC number 6251/2016, wherein the same was not allowed by the however, this court has accepted the date of birth of the petitioner to be 8/9/1957. The no, correct. The grievance of the petitioner in this case is that despite there are two cases. One is that, and there is the CID PS case number 38/2016 under section 468/471/34 IP. The grievance of the petitioner in this case is that the police have not made any final report with regard to the police cases initiated against the petition. As such, he is not being given his regular pension and other retirement benefits. He has only been given provisional final report. If you notice, the If you notice, returnable in 3 weeks, Mr.
Due comment.
Do you common accept notice on behalf of
That's point number 1, 2, and
1, 2, and 3, while Mr. Arke Talukdar accept notice on behalf of point number 4. List the matter on give in December. To enable the respondents counsel to obtain instructions as to why the police have not made any final report till date on the police cases initiated against the petition.
may I please, Your Lord? Lordship, here the State Bank of India has set up standing instruction in the petitioner's pension account unauthorizedly, my lord. That is the basic case here, my lord. So originally, the petitioner's father took a loan from the State Bank of India. Thereafter, it was covered. He also bought an insurance covering the same loan, my lord. And unfortunately, after 1.5 years, he died. My lord. Thereafter, as being a legal heir, the petitioner has been drawing the pension since then, my lord. And the petitioner's brother also is paying the same installment against the loan, my lord. But the State Bank of India had unauthorizedly put a standing instruction to recover, to deduct some amount from the petitioner's pension account, which cannot be done. Sir. That is my humble case, my lord. Here-
On what basis?
My lord, since I am a petitioner, that cannot be attached or
Why not? That is not your money. That is your father's money. Father of your father. He took a loan.
my lord. Yes, that was my father's money, but as a petitioner, as a pensioner, my lord, I'm getting that money, and from the pension account, it cannot be deducted. Even, my lord, under
Why can't it be deducted?
yes, there is a Honorable Supreme Court's judgment in this regard, my lord. May I refer this?
Yes.
My lord, will first my lord, may I kindly have the look first look the page para 2, my lord, at page 378 here. Para 2, the facts, my lord. As the loan was not repaid by the principal debtor, Durga Prasad Das, the bank in 1992 filed suit number so and so for recovery of its dues against respondent number 2 in his capacity as the loanee and against the appellant in his capacity as guarantor. The suit was decreed on 19/12/1994 by the learned additional district and session judge Bania district Bharatpur in favor of the respondent number 1 bank for sum of rupees so and so, together with interest at rate of rupees so and so per annum from the date of institution of the suit till realization. Thereafter, my lord, at page 6, para 6, my lord. The executing court by order dated 1/11/2002 directed release of the appellant's arrears and pension amount with a further direction that the hypothecated matter was to be auctioned first in terms of the directions contained in para 11 of the judgment dated so. The executing court also took the view that amounts paid towards gratuity and pension cannot be attached in view of provisions of provision G to section 61 of the Civil Procedure Code, hereinafter referred to as the code. Thereafter, Honorable Supreme Court also took the same view. My lord will get at para 33, my lord.
Yes, madam. Yeah, I don't know whether I do prediction of heard Mr.
PM recommended.
PM data learned counsel for the petitioner who submit that the loan taken by the petitioner's father during his lifetime remained unpaid due to his death on 5/9/2021. Yes. So the petitioner's father had availed of a single premium payment insurance cover on 13/3/2020 against the outstanding loan amount of rupees 9,34,558. The bank has repudiated the insurance cover on the ground that the petitioner's father had not disclosed actual facts regarding his health. That is with regard to the liver disease suffered by the petitioner's father. Next one. The petitioner's grievance is that the bank has issued standing instructions to recover deduct the loan amount from the petitioner's pension account. If you notice, turn over it for me, Miss D. D.D. Verma, access notice on behalf of respond number
123.
126. Petitioner takes steps for service of notice upon the respondent's number 4, 5, 6, and 7. By registered post is 80 within 3 days. This is the matter of the COVID.
My lord, till the next.
The interim, the prayer for interim order shall be considered on the next day.
What's up, like?
Mega party Initially, my lord, the petitioner was appointed as a sweeper. The pursuant of the WPC number 3875/2005 of the Honorable Guwahati High Court, and as well as the recommendation of the state level committee, my lord. And thereafter, he was posted as a sweeper on 23/7/2006. And thereafter,
Come to page 10. Please read page 10. Yeah. Please read. in pursuance to the Honorable Guwahati High Court order dated 3/8/2016 WPC number 22, and as per recommendation of the state level committee communicated by Government of Assam Environment and Forest Department letter 22 dated 22 subject to discharge without notice and without assigning any reason thereof, and also subject to police verification 22, who died in harness while serving in the. Who died in harness? Sri Arjun Singh died in harness. Harness. Huh? Who died in harness? Arjun Singh. Arjun Singh died in harness. Now, who is the petitioner? Arjun Singh. Arjun Singh. What? Yeah. How can you correct the official order? This is an office order. How can you correct? You know how to correct an office order? You know. Huh? It cannot be corrected. Who died in harness while serving in department is hereby temporarily appointed. Yes. So the person who died has been appointed. My lord, what can it see? Anyway, so that is some mistake in this thing. Yes. Anyway, yes, madam.
But I think his father, that is late Mohan Singh, he died in harness.
Correct. There's something wrong with
There's
your
a
order.
comma
Anyway,
there.
if you come to page 20. This is a letter by the PCCF, Wildlife. And out here, it says here that now out here, it says Arjun Singh. Correct. This letter is by Arjun Singh. Who? The petitioner. Now look below Arjun Singh. What is it? Office of the Principal Chief Conservator of Forest. Petitioner is now working in the office of the Principal Chief Conservator of Forest. What is this? Huh? These are all official documents, Mr. Counsel. Yes, you are working in the and what are you? Huh? Yes, so you are working there and you are asking for area pay, correct? Anyway, come to page 18. Page 18, I think. I think the department has accepted that he has not been given his pay. Madam, the second last paragraph, the last sentence.
Not,
But he could not. Please read that.
could not take in his monthly salary during the period with effect from 23/7/2016 to 18/12/2016, which he deserved.
So, so they,
Not the issue notice accepted.
okay, right. Right, Mr. S. Sharma. Learned counsel for the petitioner to submit that the petitioner was temporarily appointed as speaker on comparative ground by the respondent number 6. On when? On 20 on 15/7/2015. The petitioner joined the post of sweeper on 23/7/2015. Till 18/12/2016. On 18/12/2016, the petitioner's appointment as sweeper was cancelled and he was appointed as office peon in the same office of the principal of the PCCF Wildlife. That the petitioner joined the post of peon on 19/12/2000 and is continuing therein till date. Continuing. Yes, sir. The grievance of the petitioner is that he has not been given his salary as a sweeper from 23/7/15 to 18/12/2000. He has relied upon the letter number WL/PS/894 dated 8/3/2019 issued by the Deputy Conservator of Forest (ENF) in support of his submission that the state respondents have admitted to the fact that the petitioner has not received his salary from 23/7/15 to 18/12/2000. Miss M. Kalita submit that no learned counsel for
For the forest department, respondents 2, 3, 4, 5, 6, and 7.
2 to 7 and Mr. P. Nayak for respondent number 8. Submit that they will obtain instructions with regard to non-payment of arrears salary to the petitioner. List the matter on when. You just whether he's entitled or not, then we can dispose of. When
30th of November, Your Honor.
30th.
Of life.
30th.
Please, Your Honor. 30th is petition is filed for claiming the pensioner benefit by the petitioner. The respondent courtesy gives the.
What is your case, madam?
This is for pensioner benefit, sir.
Pensionary benefit. Pensionary benefits. Why didn't you get pensionary benefit? What was the reason?
The reason was that.
You are working as what?
What?
You retired as what?
No, he died in harness, sir.
He died in harness as what? What was he working when he died as in harness?
Work charge section.
Work charge section assistant.
I have an identical ballot.
That means if he's a work charge, was his service regularized? Not regularized.
The service was not regular.
Now you tell me the law.
There are 4 milots. Because initially it was milot order, single bench order, then division bench has upheld. There are 4 division bench order.
Paragraph 4.
Identical situation there. That is the law, my.
But where is the final decision?
Last in there are 24 minus 24-25. The retables were dismissed.
Yeah, revision bench judgment.
But earlier I approached the honorable court. The Lordship kindly, where is the page 40?
Page 40.
Yes. where honorable court has directed to consider my case after verification.
Correct?
So, whether I have been intimated.
Huh?
I have been intimated that case has been rejected, there is no intuition to me. They have
No.
given me the job on compassionate ground. I am serving.
You see, compassion appointment will only apply when the,
No, I am not on compassion because I am getting job. I am serving now.
then what do you want?
Now my pension I must get.
Where- why-
My
why-
husband served for 13 years.
Maybe, but then the division bench has held that unless you are regularized in terms of the rules and holding a substantive post,
I
then
was on a substantive post, my right? But suppose non-regulation is in my fault or the fault of the department.
anybody's fault maybe, but what to do? The law is like that.
Poorest of the poor employee, I cannot go and say that which is their income duty, my lord, to regularize my service. And in this poor lady now, she is being deprived of pensionary benefits of her husband.
What to do, Mr. Counsel?
Earlier, they have paid for take instruction. I do not know what instruction they brought.
No, here, the judgment is here, the law is here, whatever facts, you see the facts are very clear, you are not regularized, simple.
But they should write, submit an affidavit, they should have not done it.
No, where is your submission that you are regularized?
I am saying
Where
I'm
is
not-
your, where
I'm
is,
not regularized, yes.
then, that is
Even the judgment also reflected them and not
once they
regularized.
have said, once you have said that you are not regularized, why should they, what is their requirement to say that you are not regularized?
They must honor the judgment of dated 25/11/10 by passed by this honorable High Court.
Third, Mr. S.C. Biswas, learned counsel for the petition. Also heard Mr. Ardha, learned counsel for the
PWD.
PW. The petitioner's case is that her husband,
Well, then I am doing it.
okay, Mr. Before that, right? Then Mr. Ardha, learned counsel for the petition, for the state response submit that the present case is to be dismissed in view of the order dated 13/3/23 passed by the division bench of this court in WA number 1 of 2020. Yes, sir. Mr. S.C. Biswas, learned counsel for the petitioner, says that he may be allowed to withdraw the writ petition. The prayer is allowed, writ petition is dismissed as withdrawn.
Not this way, but put your Good.
Is closed as withdrawn.
Yes.
This is here. Yeah, you want it? I want it. It is WA 1 of 2022. Order dated 13/3/2020. Item? Where is it? Okay, right. None appears for the petitioner. A perusal of the orders passed by this court shows that the petitioner has that none appears for the that none appeared for the petitioner on 19/11/2020, 7/9/2021, 30/5/2022, and 16/10/2023. In view, Mr. Name. T. Rabba appears on behalf of respondent number 5. Anybody else? One, two, three, four. While Mr. Ardhar appears for respondent number 1 to 4. The petitioner does not appear to be interested in pursuing the matter. Accordingly, the writ petition is dismissed for non-prosecution. This also same thing. No one appears for the petitioner. As can be seen from the previous orders passed by this court, no one appeared for the petitioner on 9/3/22 and 11/10/23. The petitioner, no, Mr. B. Gogoi appears for respondent number
1, 3, 4, and 5.
1, 3, 4, and 5, while Mr. Sabara appears for respondent number. The petitioner does not appear to be interested in pursuing the matter. The writ petition is dismissed for non-prosecution.
Lord, can you the impin order page 13?
13.
Yes. 13 and 14.
Yes. You are still under suspension.
Yes, sir. So, my lord, they have filed an affidavit, my lord, on 1/4/2022, my lord, filed with the register, my lord. And in my lord, paragraph 6, my lord.
Yes.
They stated that, my lord, this board is not, is a right, specifically see paragraph 6, my lord, of their affidavit.
No, what has happened? Has the proceedings been completed? Inquiry?
No, my lord, nothing, my lord.
Not complete.
No.
Also, it is the board to be taken because it's not a government, they have to property society. It is the board who has taken the reposition and it put the petition under suspension. So who is representing the board? One number 6 and 7 are the. Huh? One number 6 and 7 are the chairman and the secretary of the. They are not here.
But my lord, ultimately, annexure 1 page.
No, no, wait,
Appointing
wait,
authority
just
is
a
the
minute,
register.
before I see something, just let me clear my mind.
Lordship mechanism page 9, Lord, annexure 1.
9.
Yes.
In the interest of so you have been appointed by the registrar.
Register.
POD on a temporary basis. Huh? POD on a temporary basis. So, if your appointment is not by the competent authority, what is wrong with your removal?
Well, that's why I have shown your lordship, the register.
No, tell me something. If you have to be appointed as secretary by the board and removed by the board, but it has been done, but the appointment has been done by an incompetent authority. Is your appointment a valid appointment? Tell me. You cannot pick and choose what you like.
But once, my lord, I have
So
been
your
appointed-
appointment is invalid. So what is your case?
Once my appointment is made, my lord,
Once your appointment is invalidly made,
board has no authority, my lord.
but you said that it is the board of, huh? Acha, it is by the respondent.
Yes. That's it. My humble prayer is, my lord, mathematics because of directing the register, my lord, to pass appropriate order. Because as per affidavit, he is the authority. After submission of the report, he will pass out.
Let us see the law. What does the law say?
Section 38 of the Assam Cooperative Society Act
What does it say?
says the board of directors is the competent authority to appoint a regular secretary, provided he is not a government employee.
And what about the petitioner?
Petitioner is not a government employee.
He's not a government.
You are
So he
working
can,
as a salesman.
so he can be appointed secretary by the board only.
And now the
So he's appointed by the registrar. So
Yes.
the appointment is invalid.
Incorrect. And more particularly, your lordship, the resolution has been taken by the court for putting the petitioner under suspension. Your lordship. That has been challenged in this petition.
Okay. So the board, so he cannot be a secretary then.
No,
But his appointment was invalid. What do you mean? What remains, Mr. Counsel?
whether my lord,
Let us see the law. Let us see the, what is that?
section 38 of the Assam Cooperative Society Act 2007.
Have we got that?
Section 38 of the powers and functions of the board.
No, where does it say about the secretary?
Lordship, the chief executive supposed to nominate, elect or appoint and remove the chief executive provided he is not a government.
Chief executive, talk about, he's a secretary.
Okay.
It's different.
Secretary, lordship, he holds the same post of the chief executive.
But they are different posts, correct? His secretary and chief executive are different posts. So then,
Otherwise, your lordship, there is a judgment of our high court.
yes,
That is Christopher Neff versus State of Assam. It might, may I place it? Your
yes, yes. Please do.
lordship? 1993, 1 BLP about.
Anyway, there's hardly any time now. There's a reference at 3:30. By the time I pass, right. On the prayer, the parties list the matter on when? List the matter in the next week. Anytime. Give a date. Next. Yes.
Let's give you on. Lordship, kindly pass the matter for debate. My figure is out.
Right. On the prayer for adjournment made on behalf of the petitioner's counsel. Any objection? Which is not objected to by the counsel for the respondent, list the matter after review. The issue herein is with regard to whether there was any excess drawl of pay. Keeping in view the different stand taken by the Director of Secondary Education made in the order dated 3/7/2017 and the letter dated 1/6/2018 issued by the Finance and Accounts Office. I said the first one, you write page 27, one page 28. Oh, no, sorry. It'll be page, by the, no, but keeping in view the different stance taken by the letter dated 1/6/2018 issued by the Finance and Accounts Officer, bracket page 28, and the letter dated 6/9/2018 issued by the Inspector of Schools, page, bracket page 29. This is the matter after. Two. Okay, give a date. What is it?
This matter we are directed to obtain instruction. Instructions have not been received.
With regard to what? Instructions for what?
Lordship, they want regularization.
Appointment has been made, appointment has been made, it's a workshop. Which has been only made, anything that required, that's expected, and he is working as a.
No, whether it has been regularized.
That's the, no, it has not been.
No, so the instruction is whether
And they can regularize it.
whether they can regularize. But there are judgments which basically shows that compassionate appointments have to be made against regularized posts, against regular posts.
Regular. It has not been made, that's the issue. That's it.
So it has to be done. Otherwise, you give fresh appointment. It's a law. You have to appoint them to on regular basis. Right. Mr.
Tutor.
T. Sharma appearing for the
Number 4, 5, and
point number 4, 5, 6 submits that he has not received instructions as to whether the decision has been taken to regularize the service of the petitioner, who was appointed as a work charge. Work charge Kalasi or work charge Kalasi on compassionate grounds. The issue to be decided is whether compassionate appointments have to be made by regular appointment to regular post, and not, and whether it can be made on work on a work charge basis. This is the matter after.
2 weeks.
This is the matter on give a date. You please obtain instructions. Otherwise, we'll call your officer.
Problem.
Lordship, petitioner is junior restriction under PNID Departmental, page 44. By this order, in terms of the honorable court order, the commissioner directed the CEO, Chief Executive Officer, to pay my remote area allowance with effect from 1/1/16. But he has given remote area allowance with effect from 1/3/2020. Area has not been paid from 16. From March of 20, he has paid.
Where is the other side?
Such as PNRD department. That's 2021 matter. No evidence.
No affidavit.
Commissioner's order has not been complied by this subordinate.
Who is appearing for PNRD? What to do?
Right. Unlimited.
Huh? On the paras, as no one appears for the PNRD. This is the matter in the next week. Next.
Monday.
No, not Monday. Too many cases Monday.
Wait, next.
Give a date.
I'm up.
दिल्ली में दिखाई दिया बहुत लोग ये तो 9 और